Yeah, refer listing admission 3rd of September. Provincialization of lordship 5th.
I have also a similar prayer on that for listing matter.
When do you want?
After the matter was last listed on 2012-2024, my lord. Yes. Yes.
Item number 38.
Height.
19 September.
19.
My pleasure.
38.
My lord, in this case, we are going to file affidavit, my lord, that may be called for, my lord.
You have not filed.
My lord.
Will be filing.
My lord. Today, my lord.
Okay. When it can be listed then?
My lord, matter may be taken up today itself, my lord.
Today?
My lord.
Today? Okay, COVID.
My pleasure, sir. I'd like to mention for listing, my lord, that's a motion matter. The last was the 5/5/2025, my lord. Any
When do
day
you want?
next
Next
week.
week.
Next week.
Take a date from him.
19.
Mr. Kaushik.
Madam, I beg to mention item number 27, madam. Madam, here we are going to file affidavit, madam. Matter will be passed over for that day, madam. I have taken the consent of others.
27.
27, madam.
Mr. R.R. Kaushik, learned. Standing.
Lordship, there is an
Say,
interim order.
Madam,
with consent from the other side, first for listing the matter. After 1 week.
madam, after petition, madam.
Why?
Madam, I have some instruction yet to become, madam.
After vacation, any objection?
There is stay, madam.
There is an interim order.
There is stay. There is a lot. Interim order pass earlier shall continue.
Obliged.
Yes, I beg to mention for listing matter next
When?
week or next week, madam. Cancel matter, madam.
What matter? What is the matter?
Pension matter, madam.
Pension.
May I please, your lordship? Lordship, I beg to mention item number 18 and 19.
18 and 19.
Yes, your lordship.
Yeah.
The matter may be adjourned for the day, your lordship.
Why?
Lordship, my senior Mrs. A. Bujobro, due to some family emergency, she couldn't come today. So the matter may be fixed on Monday, your lordship.
Next Monday.
In the coming Monday or any day. Much obliged.
On the your good name, please.
Miss A. Sharma.
Miss A.
A. Sharma.
Sharma. Learned counsel on behalf of A. Bujurguru, learned conducting counsel for the petitioner. You inform the other side.
I'm from the petitioner.
You inform the other side.
Yes, your lordship. I've
With
taken the consent.
the other side, files for the matter. On when? They took the fair.
Much obliged. May I please, your lordship? I would like to beg to mention item number 37 of the daily list. Your lordship, the test record has not been arrived yet. Your lordship may adjourn the matter for the day and fix another date.
Case record has not been received.
Yes.
Miss, your good name, please.
F. Rahman.
F.
Rahman.
Rahman, learned counsel appearing on behalf of
S. K. Nargis.
learned conducting counsel for you. The matter is hence adjourned to be listened after. When?
After
11 September, your lordship.
September. Obliged. Obliged.
Without order. Yes.
Lordship, I'm paying for listing of an IFO orders, lordship, Friday if possible, lordship. Some urgency.
When?
Friday, lordship. Or Monday. Obliged.
May I please, the lordship. Lordship, I am praying for in respect to item number 51 and 52 of supplementary list, lordship. Lordship, I am praying for accreditation. Lordship, there is some urgencies there. Lordship, petitioner is going to superannuation in the next month.
No accreditation will anyway take up the matter today.
High levels.
Please, lordship. Well, in this case, my lordship will find at page 47, impugn judgment and order, my lord. Page 47. 47 is the impugn order, my lord. On page 48 is the operative portion, my lord. 28 to 2025. The direction was given, my lord, to comply with this judgment and order within a period of 1 month. The last page it is given, my lord. Page 63, my lord, para 23.
Heard Mr. Zaid Ahmad, learned counsel for the petitioner. This application under Article 215 of the Constitution of India. Read with section 12 of the Contempt of Court Act 1971. Read with Contempt of Court, Certificate Guwahati High Court Rules 1977. Is preferred by the applicant. Mrs. Deepa Devi for willful disobedience. Provincialization of the judgment and order dated 28 to 2025. Passed by this court in WPC number 5125 of 2024. Where is the petition, the documents, license record, and the judgment and order dated 28 to 2025 in WPC number 5125 of 2024. Let notice be issued to the respondent contempt notice. Return evidence for which step be taken by registered post with AD and authorial process in quick today. This is the matter after 4 weeks.
Well.
Content petition, my lord, operative portion, my lord, page, my lord, 33, my lord. My lord, order pay annexer 6, page 32. My lord, 33 is the linked case with Rajesh Jadhav, my lord, page 33. And operative portion, your lordship, go to the page 39. Page 39.
Heard Mr. N. Bora, learned counsel for the petition. This petition under section 12 of the Contempt of Court Act 71, Schedule 30, 115. Here is referred by the petitioner for willful and deliberate violation of the order dated 20th to 2025. Passed by this court in WPC number 3091 of 2024. By the respondents, the contempt notice. Where is the petition and the documents placed on record and also where is the order dated 20th to 2025. Passed by this court in WPC number 3091 of 2024. Let notice be issued to the contempt notice. Returnable in 4 weeks. Step be taken by registered post with AD and also by legal process within from today. 4 weeks.
Much.
May I have your lordship? The matter pertains to non-payment of arrears salary lordship for a particular period lordship. The last time they were directed to obtain instructions. Lordship, at this
Let the
stage,
notice
stage-
may go
Yes.
at this stage, your lordship.
Let them file affidavit. Lord.
Heard Mr. A. Decker,
Lordship.
and he does learn understanding of
1, 2, and 3.
the respondent, secondary education department, being respondent number 1, 2, and 3. Okay. This petition under Article 226 of the Constitution of India, the petitioner has tried for his direction to the authority for releasing his salary for the period 1/4/2006 to 16/8/2010.
Lord.
Where is the petition and the documents placed on record?
Move it up, PDF, we got this.
Let's
First step from
be put to the
Look at the papers of-
returnable in
Sharon,
4 weeks.
But
That
we
be
just
taken by
did
the
one
third
PDF
group,
copy. No?
maybe and by process right? You have all the respondent.
Yes, yes, there are three respondents.
However, no further notice is required to be, since all the respondents are represented by leaders. But extra requisite copy of the petition be furnished to her during the course of the day. Ms. Dassel obtain necessary instruction and appraise this for bond for the after 2 weeks.
Obliged.
Deeply obliged. Access dual, no? Access dual. तुम्हारा convert to no?
Yes,
Yes. My lord, in the year 1998, there was a centrally sponsored scheme, my lord, by the name of Operation Blackboard. There, my lord, numerous incumbents were inducted into the scheme, my lord. I was inducted in that scheme, and at page 16, my lord, by order dated 6/5/1999, my services were regularized in that post with effect from 24/4/1998. At page 16, the lordship sees that.
Little elementary asset. Four.
page number,
Page number 16, my lord. Page number 16, annexure A. In pursuance of government letter number so and one post sanctioned by the Director of Elementary Education Assam against Jamuguri MEM by letter dated so, the service of the following working teacher has been regularized with effect from 24/4/1998 in their respective school, showing against the name in the scale of pay of so and plus other allowances. My lord, my name features, my name is Ubbad Ali. My lord. I can continue, man.
yeah,
Yes. So, my lord, this was pursuant to an Operation Blackboard scheme, my lord, which was a centrally sponsored scheme. That scheme came to end sometime in the year 2010. Thereafter, my lord, the petitioner and other similarly situated individuals continued rendering their services. Thereafter, your lordship will kindly come to page 17, annexure B. Those incumbents, my lord, who were initially appointed pursuant to Operation Blackboard were adjusted against various posts that has fallen vacant in various government schools, my lord, and upper primary schools in the state of, in the district of Nagaon. The petitioner's name features at serial number 9. Ubbad Ali, my lord. But what has transpired, my lord, after the culmination of Operation Blackboard, since these teachers were not regularized under any vacant post at that point in time, the teachers moved before the Honorable Guwahati High Court, this court, my lord, which is at page 19, annexure C. Subsequently, my lord, by order dated 19/5/2015, directions came to be passed, my lord. The directions are at page 22. Paragraph number 7. In that view of the matter, this writ petition is disposed of with the direction to the respondents to finalize the regularization of the petitioner services from 24/4/1998,
Definition खिलीमिली हुए सर.
payment of regular salary as per pay scale prior to 22/8/2010, and examine and decide the question of payment of pension to the petitioners as indicated above within a period of 3 months from the date of receipt of the certified copy of this order.
खिलीमिली हुए सर. Ubbad Ali, no? Little खिलीमिली हुए सर. Okay. In my repetition, it was showing, reflecting something else, your lordship.
22 keywords.
petition disposed of.
Disposed of page 21 of what it is, because we got.
And your lordship,
Yes.
page 21 shows, and it is also not readable. The copy which the petitioner had served. It is not readable also, your lordship, and the your lordship pages which he denotes your lordship, it is not here, your lordship. It was not readable also, your lordship. And he was denoting page 20,
Available copy?
Yeah, madam, we'll do that, madam.
22, whereas in my read petition, it was in
There are certain,
21.
there are certain defects, my lord, we'll move it on Friday, madam. We'll try the defects, yes. Of your lordship deems it acceptable, we'll furnish copies to the petitioner as of now, my lord, respondent as of now. I'll leave it to your lordship's convenience, my lord.
Some
To her
Friday?
other day,
Friday,
your
Friday,
lordship.
Friday. Great.
Deeply obliged.
on the pair being made by the server, and for the petitioner, that the subject of the Friday. In the meantime, is the server.
Second copy, second right.
Of the petition and the 11th of.
Oh, sorry.
Yes, he does learn it's nothing
Mm.
of the respondent.
Deeply obliged.
May I appear, your lordship? The petitioner here was appointed as a contractual teacher also. Assistant science teacher science, graduate teacher science, your lordship, in 2010. The contract. It is annexed in annexer A1, lordship, page number 14. His provisional certificate, Jagged Road Police. Then the contractual agreement, lordship, is page number 15, lordship. Then in 2000,
What is your pair in this petition?
where is lordship, my seniority may be considered, lordship. From 2010 to 2022, I was in Bothal Higher Secondary School, lordship.
Where to be considered?
Lordship, I was in the school from 2010 to 2022. Then I was selected for TET. In another, I was appointed in another school, and again through mutual transfer, I came back to that school again later. I want my seniority to be considered, lordship. Nothing else.
Whether rule permits?
Lordship, after filing of this writ petition, I received my office notice, lordship, but it was not annexed. Lordship. Notification, lordship, of 21/8, lordship 25, wherein the teachers regularized under a special recruitment drive shall be headmaster and principal of secondary, high secondary, senior secondary school, provided he or she possesses requisite norms as prescribed under the Assam Secondary Education Provincialized School Service Rules of 2018, lordship. This is notification come on 21/8/2025, lordship. Just the day I.
Bring on record by
Lordship.
filing an additional.
That is my lordship.
Heard means that
UP Chalia, lordship.
learned counsel for the petitioner and Mr.
You Sharma,
You Sarma learned standing counsel for the respondent in higher education or
Secondary Education Department.
part.
Well, I am respondent number 1 to 4, my lord.
One
Yes,
of
Well,
the Solihan submits that he may be granted some time to bring on record one notification issued by the government on
21/8/25, lordship.
2025
Hmm.
after filing of the present date. There is accordingly allowed present that is the matter on next Monday.
No, lordship. Can we have, no, lordship, on 15th, lordship.
15
lordship.
September.
September. No, in the meantime, notice may be issued, lordship. Notice may be private respondent, lordship. Yes.
no, my lord, actually, this matter is a premature one, my lord. Here, my lord, kindly come to the prayer portion, my lord. Page 11.
Basically.
It is therefore prayed that your lordship be pleased to admit the application call for the record of the case and issue a rule calling upon the respondents as to why a writ of mandamus should not be issued to the respondent to show cause the seniority of the petitioner while preparing the seniority list in case of requirement of the present principal. Principal is still here.
Interim
Present
was-
principal of Barthal
Doloigaon.
Doloigaon Higher Secondary School, and as to why the seniority of the petitioner in his service as a graduate teacher should not be counted on the basis of provisions of elementary and secondary education and Rule 2020 Act 2000. After hearing the parties and presenting the records, issue necessary direction giving the seniority in service to the petitioner and or pass such order and orders, your lordship, deemed fit and proper and for
Process is yet to be started.
Yes, process is not started. Lordship.
Then- How your right actually?
Mm. The petitioner fears, Lordship, he may not be considered.
yes.
He fears, Lordship,
It is his
seniority may
prediction.
not be considered.
Whether on the basis of fear,
Hmm.
you can maintain a
Apprehensive, Lordship.
petition.
He is apprehensive, Lordship.
Huh?
He is apprehensive, so he has filed it.
You bring on record that notification, we will say, we will not issue notice right now.
Well, let it be on 8, Lordship. Let it be on 8.
On
8.
8.
8.
Oh, all right.
8 September. Applies, Lordship.
May I please, Your Lordship? So here the petitioner retired as assistant teacher, Lordship, on 31st March 2024, Lordship. But his pension has not been finalized due to an objection raised by the Director of Pension that his fixation as on 1/1/2006 was wrong, Lordship. Lordship, may come to the last page, page number 13.
Page number?
13, last page, page number 13. Last column, Lordship. Last row. Fixation on 1/1/2006 may be fixed at rupees 9,100 instead of 10,660. May be clarified from LPC of Finance Assam may be submitted. Our petitioner, Lordship, appears that his excess royal amount may be recovered from him, Lordship. The pension papers sent back to the Inspector of School, Nalbari, Lordship.
Oh, whether any notice was issued to you,
Lordship.
whether they have issued any notice to you,
No, Lordship.
then
Lordship, he come to know that his pension has not been finalized, Lordship, due to this objection, Lordship.
objection was raised by who?
Director of Pension, Lordship. Last page, this is the seat, Lordship, maintained by the Director of Pension, Lordship.
Who is appearing for Directorate of Pension?
Director of Pension. First list of action and pension. First list of action and pension.
Whether you have served notice upon response number
Lordship,
4,
Director is
Director of Pension.
Lordship, respondent number 4 and 5, Lordship, Director of Pension. Normally B Deuri appears.
Third is that
PK Das. Lordship, one more prayer, Lordship. My interim prayer is that the petitioner has not been paid provisional pension also. For this last year, Lordship, more than 1 year, Lordship, he has not got a single penny.
when he had retired,
Lordship, 31st March to 2024, Lordship, more than 1 year. And he is the only earning person in the family, Lordship. Without Lordship, after retirement, without any money, it has become difficult for the family, Lordship, to run, Lordship. So, provision is there, the provisional pension may be paid to him during pendency.
Well, in this regard, I have to take instruction from the department also here regarding the provisional pension. I have to take instruction regarding the provisional pension from the department.
why it was not paid?
Yes, my lord, so that I have to take instruction.
Normally, my lord, nowadays, due to online, the pension is finalized very shortly, Lordship.
Hmm.
But due to this objection, It is lordship, lingering lordship. So lordship, provisional pension may be paid with immediate effect. This issue may be settled. This may be issued lordship.
Mr. Devi, have you received the notice?
Of this pay fixation.
আজি প্ৰথমবাৰ অহা নাই জানো প্ৰথমবাৰ অহা নাই জানো Lordship, it has come for the first time, so may I be allowed to obtain the instruction, Your Lordship?
But in the meantime, pay the provisional pension.
That will do. Provisional is paid by the department, parent department.
I have to take my instruction, my lord.
Nothing to that instruction.
At least 2 weeks may be granted.
Great lordship. If
This is
not,
the first day, my lord, 2 weeks may be granted.
For instruction.
Yes, fine.
No problem.
1 week, 10 days or 10 days.
lordship may direct, if not paid provisional pension, it may be paid. It is not paid.
Heard Mr.
PK that.
Earned conflict for the petition. And Mr. Devi for respondent number
I'm for 4 and 5, Your Lordship.
5 and Mr. Yu Sharma for respondent number
1 to 3.
1 to 3. And Mr. Solia for respondent number 6. This petition under table 26 of the petition of the petitioner has tried to issue direct first to forthwith release the pension and pensionary benefit under the provision of the Assam Services Certificate Pension Group 1969 without making any recovery from the pension of the petitioner. Pension of the petitioner. Mr. Das learned counsel for the petitioner submitted that the petitioner retired as assistant teacher crafts on 31/3/2024 from Balsor Higher Secondary School under Inspector of School Nalbari District Circle Nalbari. After retirement, the petitioner has submitted his pension papers to the Directorate of Pension, Assam. Wherein a discrepancy has been detected by the financial account officer by office note dated 10/7/2025 and 14/7/2025 with regard to the fixation of pay of the petitioner. By making an observation that fixation on 1/1/2006 may be fixed at 9,100 instead of 10,660 rupees. And thereafter, the pension paper of the petitioner has been returned by the respondent number 3. Returned to the
Excess
respondent number 3, the inspector of school,
Excess
with an intention to recover the excess withdrawal from the pension of the petitioner. Mr. Das further submits that the petitioner, after retirement of the petitioner on 31/3/2024, more than 1 year elapsed, but till date, the provisional pension of the petitioner has not been paid by the respondent authority, for which the petitioner has been suffering a lot. And under such circumstances, Mr. Das contented to issue notice to the respondent and also to issue interim direction to the department. Respondent number 120 to release this provisional. The submission of Mr. Das needs further consideration at this instant. Notice be issued to the respondent. Returnable in 2 weeks. However, no formal notice is required to be issued, since all the respondents are represented by their MP's counsel. However, extra requisite copy of the petition be furnished to them during the course of the day. Mr. Devi learned counsel for the respondent number 5, 4 and 5. Then Mr.
Usual.
Learned Standing Council for the respondent number 123 shall obtain necessary inspection and advise this court on public. It is being clarified that pendency of this petition would not be a bar in releasing the provisional pension of the. Mr. Sharma, you asked the respondent to release his provisional pension.
Extra copy develop.
Extra copy, extra copy. Item 7.
This is matter regarding recovery of excess royal lordship. Petitioner was an assistant teacher of a high school lordship. He retired from his service on 28
Part number 2.
2018 lordship. Then lordship pays 18 lordship. After his retirement lordship, provisional DCRJ and provisional pension was sanctioned lordship. But lordship on 1/1/1996, his pay scale was wrongly fixed at rupees 3250 instead of rupees 3190 lordship. As a result, lordship, there was a excess royal lordship. Now, lordship, after 7.5 years lordship, the director of pension by his order dated 16/5/2025 lordship, page 25, has regularized the pension and with a direction to recover the excess royal lordship. Page 25 lordship, last paragraph.
Every,
Yes, your lordship.
there is a notification of the government.
Yes, yes, of the finance.
Why that the notification is not followed by the department? Followed by the directorate?
Page 31 notification.
Additional.
Page 31 is the official level.
Lordship, yes, next notification to your lordship.
33 lordship, from page 33, it is clear it is not due to fault of the petitioner lordship.
So since this notification is within the knowledge of the authority, but in spite of that, why they have not taken into account? So at lordship may fix a short date, I may obtain one instruction with regard to this.
Heard me, sir?
Yes, sir.
Learned from Court of Every.
I'm
Council for the respondent number.
I'm for 6, your lordship.
I'm appearing for 1, 2, and 3.
6 and 7.
He knows for respondent number
1, 2, and 3.
1, 2, and 3. Mr. Sophia for
4 and 5.
4 and 5. 4 and 5. The petitioner is agreed by the order dated 16/5/2025 to get an entry. By
It's 21 now. 31.
the respondent authorities
Are you
have directed to recover the excess payment of rupees 1,16,666 against the head of provisional PCRG and rupees 93,216 against the head of provisional pension of the petitioner. And also to issue direction to the respondent authorities to waive the said excess payment of rupees 1,16,066 against the head of provisional PCRG and rupees 93,206 against the head of provisional pension, which was received by the petitioner due to wrong fixation of its scallop pay on 1/1/1996 by the responsible authorities. Mr. Along Learned Counsel for the petitioner submits that the petitioner retired from retired as assistant teacher of Bukdokakana Ganojati High School on 28/2/2018. And since then, he has not been receiving the pensionary benefit. You have not received any benefit.
No lordship. Provisional pension was granted lordship, and DCRG also granted by order dated 13/8/2018 lordship. But pension is regularized by order dated 16/5/2025. which is impugned, your lordship. Page 25, lordship.
He has received the provisional pension and some portion of the DCRC.
Yes,
DCRC. But his pension was finalized by order dated 16/5/2025, Annex 3. Annex 3. And by state order, the respondent authorities have initiated the process for recovery of 1,16,666 rupees against the head of provisional CRT and rupees 93,216 against the head of provisional pension of the pensioner. And that in view of the notification of the department being number FIN from EC dash Roman 3 1808001 from 2/14/2019. And also in view of the decision of including the case of state of Punjab and others versus Robic passes by Tussar. CA number 11527 of 2014 arising out of SLP vacancy number 11680 of 2012. The respondent authorities are of entitled to over the excess drawer. Excess drawer. And the same was lost on account of also the Boxers count. Mr.
You're very clumsy. Very clumsy.
Issue direction to the respondent authorities to waive the excess drawer amount. Per contra, Mr. Devery learned accounted for the respondent number so and so instead.
Lordship, may I one, Lordship, on perusal of this page 31, your Lordship. And since the petitioner is an assistant teacher, so he comes under that grade 3 employee, your Lordship. So since this notification is clear, your Lordship can interfere also with the same. Because, yes, today itself, your Lordship. If your Lordship pleases.
I can, but why they are not following this?
That I can once. Because in spite of knowing,
Every time.
yes. That I can take up the issue once.
Already was office memorandum is there. Prohibiting recovery of the excess drawer. He may be granted some time to obtain inspection from the director. Clearly, it's according to law. That's a business method. Or
lordship, till then, respondent authorities may be destined.
part of the term. So you are receiving the provisional pen.
Yes,
Extra copy did you, huh? Extra copy.
till then, they may be restrained from recovery any amount.
Pardon?
Till then, they may be restrained from recovery any amount.
In the interim, considering the submission of pardon provided that without leave of this court. No
Question.
and from the
You can
provision of the, no, from the pension of the.
Masam.
Madam.
May I please, your Lordship? Lordship, this matter pertains to compassionate appointment. The petitioner's father died in harness in the year 2012. And during that period, Lordship, the petitioner was minor.
After coming to knowledge of the compassionate ground scheme of 2015, he accordingly he applied for the compassionate appointment. And during that period, Lordship, the DLC meeting was held, and his his case was recommended to the SLC, wherein Lordship, the SLC rejected his case, claiming that there was a delay of 1 year, Lordship. And aggrieved by their Lordship, I have approached this honorable court by WPC 5127 of 2023. Your Lordship may peruse the order of the case, Lordship, Annexure 5, page number 29.
Yes.
Yes, Lordship. As per that order, Lordship, the impugn decision was set aside, and his case was remanded back to the SLC for fresh consideration. Now, Lordship, thereafter, I have also sent a representation, but they have not considered my case, Lordship, the respondent authority.
Since your lordship already on earlier round, he has the order in his hand, your lordship. So the matter can be placed in the next SLC. Next SLC.
Pass the order.
Much obliged, Lordship.
Okay, next.
My lord, this matter regarding provincialization of service of petitioner who has been working as a grade 4, my lord, in a ME school, my lord. His appointment letter, Annexure 1, page 10. He was appointed by the managing committee on 4/3/2001. Thereafter, on the basis of this appointment letter, he joined, my lord, by his joining letter at page 12, Annexure 2. In the meantime, my lord, one act was, my lord, enacted by the state government of Assam, my lord, and this act is called the Assam Education Provincialization of Service of Non-Teaching Staff of Venture Education Institution Act 2018, amended in 2020, my lord. I've stated it is at paragraph 4, my lord. And as per the provision of this act, his name, my lord, along with other grade 4 employees of the same Kachar district, my lord, was forwarded by communication at page 14, Annexure 3, dated, my lord, it is once, it was forwarded, my lord, on 18/9/2021 by the district elementary education officer, Kachar, Silchar, my lord. It is to the director of elementary education, and his name is appearing at serial number 19, my lord. Serial number 27, page 19, my lord. Shingar 37, page 19, 37, my lord. Name of the block elementary education officer. It is called, my lord, Lokipur, Singarband ME School, and his name is, my lord, column number 5, Farijuddin. Then again, my lord, in the recent year also, his name was forwarded by communication dated, my lord, 14/11/2022, page 24, Annexure 4. And here his name is appearing at serial number 9, my lord. Same Singarband ME School. But his contention is that, my lord, some other candidate of the same list were given the benefit of provincialization, but his claim was not considered, my lord, by the SL state level committee, my lord. In a, my lord, similar issue, this honorable court, as regards, my lord, teaching staff, passed one judgment order, my lord, page 25, and relevant portion, my lord, page 29, page 29, paragraph 7, my lord. In this case, my lord, as regards, my lord, teaching staff, my lord, direction was given to the SLC to consider and dispose of the, my lord, this claim.
Yes, who is for the respondent authorities?
Madam. I'm for respondent 1, 3, 4, and 6, madam. But in this case, any notice may be issued, madam, at this stage, madam.
Notice.
Yes, madam.
So only have for
Lordship, I'm appearing for finance department.
respondent number 2.
Respondent number 2, Lordship.
5. Who is for 1?
I'm appearing, madam.
Or Mr. A. Borgonia learned something. And over learned think of the respondent. Elementary Education Department Regularization number 1, 4, and 6.
Yes, madam.
And so Solia for respondent number 2. And Ms. What for respondent number 5. 5. 5. It's prediction under Article 2. As 5 points in prediction to the respondent authority for provincialization of the service as get one. In Sikarban, any federal size authority, the server Assam, education, provincialization of service of non-teaching staff of answer educational institution amended in 2020. Borgonia learned for the petitioner some extent. The petitioner was appointed as grade 4 in Sikarban MP Madrasa by order dated 4/3/2021. And he joined on the same day. And since then, he has been rendering his service in the side post. So for me, a further some extent, as per provision of the Assam Education and provincialization of services of research and reorganization of 2018, the service of basic staff of the Singarpon ME Madrasa School, Kasar, has already been provincialized in of February 2021. But in spite of the name of the petitioner being forwarded and also being eligible for regularization, yet the service of the petitioner has not been provincialized illegally and arbitrarily. And under such circumstances, Mr. Bowman is contented to direction and correspondent offer for provincializing the service of where the submission officer for Mia learned and complete for the petitioner is further completed. That is, it's a notice being issued to the respondent. For weeks, the big ticket by time. How about more from the notice will take to the respondent, since all of them are represented by their engagement. How about extra requisite copy of the books furnished to them to make the books of the day. List the matter after 4 weeks. In the meantime, the respondent authority may file their affidavit in book.
My lord,
Please.
reply.
Obligement.
May I please, Your Worship? My lord, here lordship will find, my lord, the improved, my lord, district level scrutiny committee meeting that your lordship will find at page 19. And page 21 is the, my lord, operative portion. Lordship will find, my lord, the serial number is not mentioned, but it has been indicated, my lord, Hindi, craft and music. These are the, my lord, three teachers. They have been dropped from the benefit of provincialization. As lordship will find, page 21,
Which part of
Page
the page number we have been indicated?
my lord,
Where?
page 21. This is the recommendation of the district scrutiny committee. Page 21, lordship will find middle portion, subject taught, here below, Hindi, craft and music. Lordship got it. These three teachers, Hindi, craft, music. Right hand side column, lordship will find, does not permit as per the Act 2018. Does not permit as per the Act 2018. Does not permit as per the Act 2018. Now this is in
Page number
contravention of
21.
my lord, page 21.
Column number?
Column number, my lord, it is said, my lord, subject taught, lordship will find of, and
Nine.
below Hindi,
Serial
craft
number.
and music.
9th.
15 line.
Yes, my lord. Hindi, craft, music. These three teachers have been dropped, saying that does not permit as per the Act 2018. And Mulot, they have joined Mulot, right hand side, there is a date Mulot, 8/8/2001, and craft is Mulot 1/2005, and music Mulot 1/2005. Now Act says Mulot, it is permitted Mulot. Lordship kindly see Mulot section 2J of the Act 2017.
Notices are. Why they will do this?
Section 2J.
Page number?
Page Mulot in my book Mulot 103.
Yes.
Section 2J. It says Mulot employee.
Section?
Section 2J.
Yes.
Page 103. Employee means includes all serving teachers and tutor, as the case may be, of the venture educational institutions who have been appointed and joined in the concerned venture educational institution before the first day of January 2011 and whose services are being or would be provincialized under this Act. Now they have joined before the cut-off date, Miller. Then Lordship kindly see Section 4 to Roman 4. page my lord, 114. Section 4, my lord, subsection 2, then my lord, Roman 4, page 115. Lordship got it. It says, my lord, Roman 4, in case of teachers and tutors of the school for the special subject like Sanskrit, we are not concerned, my lord. Arabic, Hindi, we are concerned with Hindi, craft and music teachers and other classical teachers. The number of students appeared in the concerned final examination, like SSLC, HSS conducted by the SEBA or the SSLC, as the case may be, shall not be less than 10 students in each class per year during the last 3 years. That is the criteria. And that criteria has been, my lord, fulfilled. Despite that, my lord,
Where is the relevant data?
my lord,
Where is the relevant data?
the my lord, last year, my lord,
Yes,
that is, of course, we have to, my lord,
then,
bring on record.
then,
My lord, my limited period, my lord, let notice be issued, my lord. And in the meantime, we will file, my lord, the additional affidavit, bringing whether we have fulfilled or not, my lord.
no, you first, furnish the data,
My lord.
thereafter we will consider it.
Yes. In that case, let it be on, my lord, on Monday, my lord, we will file the additional affidavit, bringing on record. Last 3 years, sorry, to lower.
During last 3 years.
Last 3 years. HSLC, final exam appearance, number of candidates.
So though you have not enclosed the data, whether you have mentioned it in your petition also that the required number of students were there in those 3 years.
Yes, it has been just stated, my lord, we have fulfilled the terms and conditions as provided under the Act. Those specific query lordship has, my lord, asked for, it is not specifically stated. We will bring the, my lord, record.
Or is there any model learning?
Yes,
He does learn starting of
2, 3, and 4. Respondent.
year 4.
2, 3, and 4.
Year 4. That of 4.
I am for example number 1, 5, and 6.
1, 5, and 6. 1, 5, and 6. It's the model learned concept for the petitioner submits the activity gathering some time to bring on record the number of students appear in the SSLC.
My lord, SSLC.
SSLC examination during the last 3 years. In which year your case was considered?
My lord, 2019.
2019.
Yes,
Preceding 2019.
my lord.
Preceding 2019.
16 to 2019.
2019. There is accordingly allowed. Let's leave the matter on Monday. Wednesday.
My lord. Obliged.
Deeply obliged. Last 3 years.
May I please, Your Honor?
Rupees 9 lakh.
But the petitioner was appointed as an assistant teacher in a Miss School in 1994. That was on 15th in 1994. Actually, Annex 1 is the appointment order. That's it. Thereafter, the petitioner was transferred to the present school, and she was transferred in the year 2004. And the type copy lot will find at Annex 3, page 17.
So according to you, you are the senior.
I am the senior lordship. My date of appointment is 15/3/1994. So for the respondent number 5 is concerned, she was appointed on 1st of February 1996. Lordship will get from the Annex 4 the confirmation order. Of course, there is also some topographical error. Annex 4, page 19. The original copy lordship will find at page 20. But it is not very legible, but I have given a type copy Annex 4, page 19. My name is at serial number 3, Manwara Begum. Let's you kindly see the date of joining, page number 19. It should be 16/3/1994.
And so for the restaurant number 5, that is Hasna Hara, that is serial number 5, 1 to 96. Now, after retirement of the earlier headmaster in the month of January 2025,
Your name is
my name is at serial number 3, Manwara Begum. Serial number 3. There is no dispute, Lordship, regarding the seniority, Lordship. Lordship, kindly see now come to page 21, annex of 5.
page number.
Page number 21, annex of 5. This was the first after retirement of the earlier headmaster in the month of January 25. From the proposal of the block elementary education officer, the DO has allowed to hold the charge. This was issued on 14th of February 2025. Original copy, page 23.
Usually the senior most teacher is
Lordship, at this stage, my lord, I pray that notice may go.
No, I'm coming to that, Lord.
My lord,
Now, Lordship, what happened, Lordship, when I came to know that the junior teacher is allowed to hold the charge. Normally, Lordship, the senior most teacher of the school, she is allowed to hold the charge. Then I filed representation on 2 occasions, but without considering that those 2 representations, Lordship, they again issued the impugn order on July 2025. That Lordship find at page 30, annex 9. Now again, after expiry of the 3 months period, now she is allowed to again continue by this order of 9th of July 2025. Now I am not on the inserted, Lordship. Lordship, kindly come to page 31, annex 10. From the respondent authority, there is a direction is given to the inspector of schools, Lordship, for documents verification to prepare the graduation list. So accordingly, Lordship, the schedule of date is also given. Accordingly, the teachers of the district also submitted the documents for preparation of the graduation list. Now, somehow also I managed to collect a copy of the graduation list that Lordship find in Annex 11, page 33. My name is at serial number 236. But her name also, I verified, her name did not appear in the graduation list. My school submission is that the authority may go for regular selection of a headmaster, Lordship. And admittedly, from this facts of the confirmation order, I am the senior most teacher, Lordship. So Lordship may interfere with the impugn order of 9th of July. And in the meantime, Lordship, they may be directed to obtain instruction regarding the present status to fill up the post on regular basis. Because this insertion is going on since January 2025. Even they consider the graduation list, then I may be, Lordship, promoted, Lordship,
Lordship,
because I am the senior most teacher.
my submission in regarding this case, my lord, is that, my lord, if your lordship comes to page 20, annex of 4, the main copy, my lord, is not legible as per the my lord, seniority of the petitioner as well as the private respondent number 5. The annexation number 4. Therefore, my lord, I pray that, my lord, notice may go at this stage. Let the private respondent come, my lord. Let her come. Let her place her case. Before placing her case, my lord, there might be some other reason because, my lord, the annexure 4, page 20, he has given a type copy, my lord. He has given a type copy at page 19. Annexure 4, page 19, which is a type copy, but the annexure 20, which is the original copy, the numbers your lordship sees, the dates of the year is not given properly. So therefore, my lord, I would like to, my stand is that, my lord, I would like to verify it first before, my lord, any stay is given. Lordship will have it in the next one, after a week, my lord. I will produce the instructions, my lord, whether this thing is correct or not.
Friday,
In fact, my lord, 10 days, my lord, will be given because it is, I think, district is, my lord, Nagaon. So, my lord, 10 days will be given. In the meantime, I'll get the instructions. Plus, let the private respondent also come, my lord.
So based on this document,
She should also get a right, my lord, to defend her case, my lord.
so based on this document, also already they have impugned order issued in the month of February 2025, taking into account of this letter. So let's say take fix on Friday then.
Friday is too early, my lord. Let us be fair, my lord. It's in from Nagaon, my lord. Some 10 days will be maybe given.
It is in the office of the director, Lordship.
My lord.
or Mr. A. Das.
Hey, Decker.
A. Decker or Decker. Sir. A. Open or Decker.
1 to 4, my lord. Respond 1 to 4. Respond number 1 to 4.
1. 1. Article two, but it's- we just have this part as practical direct. The respondent authorities to review the order dated 9/7/2025 and to determine the interest security of the petition and the number 5. And also to issue direction to the respondent to avoid the petition. Yes. Regular headmaster from administration of guide down and use on the basis of credits of this 2025. Sir, Jeka learned conflict of expert submits that the petitioner is the senior most teacher of guide down any school of the door. As per traditional list. But despite being senior, the respondent authorities have appointed the respondent number 5 as the insert headmistress of Gainka and his corporate.
My specific allegation is that her name did not appear in this so-called gradation list recently prepared in the month of
Even though
July.
our name do not find mention in the gradation list of the year.
And also, this was prepared in the month of July 2025. Of course, it's a provisional gradation list, July 2025.
Under such circumstances, Mr. Dekka has contacted to interfere with the order dated 9/7/2025. The submission of Mr. Das. Dekka needs further consideration and assistance notice made to the correspondent regarding 2 weeks. Sleep upon respondent number 5 taken by registered post with daily and also by the process within a week from that. However, no formal notice is required to be sent to the respondent number 1, 2, 3, and 4. Since Mr. Bokon and third appearance and principal. Extra set copy of the something furnished to list of after 2 weeks. In the meantime, Mr. Bernard standing counsel for the respondent number 1 yet code 4 instruction in respect of annexure 4. Annexure 4 on next day.
Deeply average. Deeply average.
Let's make an offer. The interview on non-returnable day load. Admittedly, I am the senior most teacher.
I know that part will be
I mean,
verified on that
right.
day, my lord, because that day the thing is
On
not
next
listed.
day,
Lots of there are
the
full
chair, the petitioner will be considered.
lot.
Right.
How does? May I please? Pilot.
Yes.
In this case, the order petitioner before a lordship, my lord, qualified NEET in 2025 and thereafter participated online counseling under the Divyang quota, my lord, PW, physically handicapped person. He was, by notice dated 18/8, he was allotted seat. Thereafter, my lord, after allotment of seat, he was asked to appear before, my lord, medical board to assess the disability, my lord. Thereafter, my lord, the interim notice was published where his name has not been included. For the reason not known to the petitioner. The petitioner has not given any reason as to why his name has not been included. Therefore, my lord, I am before your lordship, my lord. Here, your lordship kindly peruse page 19. This is the disability certificate.
Page number?
19. This is the certification issued to me on 23, my lord, by Joint Director Health Service. He is the certifying authority, my lord, in view of section 57 of the Act. So this certificate contains, my lord, certificate number, that is, and also registration number as Divyang. My lord has got it, my lord. Thereafter, your lordship find, I have qualified NEET. This is page 20, my NEET scorecard. My PWD rank, category PW rank 1103, All India rank. General PWD. My lord got it.
Yes.
Thereafter, my lord, I have participated online counseling. Annexure 3, page 21. This is my application printout or application form. And then on page 24, 18 August 25. My lord got it, page 25, 24. This notice was published where, my lord, notifying the all qualified candidate who were allotted seat for MBBS admission. And your lordship will find page 25, fifth line from bottom, my lord. My name appeared. Page 25. Fifth line from bottom. 1, 2, 3, 4, 5. Fifth line from bottom, my lord. 2849, my serial number. 3059, my NEET number, etc., etc. Rakibul, General, PW, and seat was allotted to Tezpur Medical College. My lord got it. Then this is the cause of action, my lord, page 26. After publication of 25 list, 24 and 25, all candidates allotted seat under disability quota, my lord, were asked to appear before the board for disability assessment. So I also appeared. Here the page 26, a list of, my lord, 7 candidate published. My name is not there. Why this is not there, my lord? That has never been made to know.
My lord, my lord, the relevant rules, my lord. The provision of the relevant rules, my lord, provides that, my lord, your lordship may peruse the relevant portion, my lord.
Yeah, rule 2.
The relevant portion I have marked, my lord. The DME shall constitute a medical board consisting of not less than 3 heads of the orthopedic department of the medical colleges of Assam or their representatives not below the rank of professor of orthopedic department for assessment of disability of the student seeking admission at the time of counseling. So in terms of the provision of this rule, my lord, a medical board has been constituted. The report of the medical board also I have produced before your lordship.
Where is the report?
Yes, it is in the separate sheet. Okay. So that is the report in respect of, my lord, all the persons who have applied under this quota, my lord. So at serial number 44, your lordship will find the name of the petitioner. So he has been adjust as, my lord, 15% disability only. The last page at serial number 44, my lord. So his disability percentage is only 15%, my lord. Last page, my lord, 44.
Yeah.
Yeah.
So the candidates between the disability of 40 to 80% are entitled under this quota, my lord. So since he has been, his disability has been found as 15%, my lord, so he is not eligible, my lord.
So what is the range of disability for
40 to 80%, my lord.
40?
40 to 80%.
40 to 80%. Where it is mentioned?
My lord, it is not there, my lord. The rules, in fact, my lord, the petitioner has also not annexed, my lord. But I can find a short affidavit within a short time, my lord.
Rule is
But
there.
this is the preliminary instruction. So as per the medical board report, my lord, his
It is there.
disability is not there within the defined 40 to 80%.
As
And
per
as per
rule,
the report, his disability is only 15%, my lord. And this board has been constituted if your lordship sees the members, my lord, with the head of all the department, my lord.
here, my lord, as per rule, prior to its amendment in 2024, the criteria, my lord, the benchmark disability was marked 50 to 70%, in between 50 to 70%.
Where?
Your lordship kindly, peruse, I have given the,
Page number?
yes. Page 28.
No, of this rule.
Yes, of this rule, I have given, my lord. Before that, your lordship, kindly come to the,
Yes, 50 to 70%.
yes. This is 2017 rule, 50 to 70%, but there is also a provision up to 40 to 50%. So my certificate says it is 40%. Now this rule has been amended. Now what is come, my lord? Page 30, your lordship will find. 13th March 24. Earlier was first page, your lordship will find. This rule was 1st July 17. Page, very first page. And now page 30, your lordship will find. Here what is said, my lord, page 37. Now percentage is not, my lord, requirement. What is the percentage of disability? This is gone. Your lordship will find page 37. My lord, got it, my lord, page 37. Column Q of the rule, my lord, I have given you. Column Q. My lord, got it, my lord. Right hand side, my lord. Specified disabilities. Now it is required specified disability. Percentage is now not a matter, my lord. Now it is required specified disability. Now what is specified disability, my lord? Your lordship now kindly come to the act, my lord. The Right of Person with Disability Act 2016. The act has defined specified disability at, my lord, section 2 ZC. My lord, got it. Section 2,
Yes.
24. Page 30, sir. Last of page 30, nothing to this. My lord, got it, my lord. ZC, section 2 ZC. Specified disability. Very long queue. Last, no matter.
Where is the schedule?
Schedule, yeah. Schedule is at the last of the section, act, man.
Page number.
last page. Page 48, man. After section 102, at the below. Mallet got it, man.
Yes.
Locomotor disability, a person's inability to execute distinctive activities associated with movement of self and object resulting from application of musculoskeletal or nervous system or both, including this one. So this schedule now, there is a notification under guideline how to assess disability, how to assess delivery. This guideline is there. What are the requirements? Your lordship will examine whether the assessment is as per the guideline. This guideline is in this book also, very much there in this book. Guideline for, in my book, page 115.
So then let him file affidavit.
Yes, my lord.
And another aspect, my lord, here because from today onwards, the last round of counseling, formal last round of counseling is started. And on 5th, my lord, the final list will be published. And so far my information is concerned, from the 1st of September, session will be started. So at the interim, my lord, my humble submission would be one post.
He is not entitled for interim because as per the report, you have, your lordship has
What is the report?
only 15%, my lord.
Supreme Court has said quantification is not the criteria, my lord. Quantification, I have with me the Supreme Court judgment. If your lordship bear with me for a moment, I can produce before you.
So say in the meantime, let.
Yes, my lord. Therefore, in the meantime, my humble submission, one seat, I am not praying for that entire process, my lord. One seat may be kept, my lord, vacant for the petitioner, my lord.
So will I take it up on next Monday?
Yes,
In
my
the
lord.
meantime, you
Yes, my lord.
file your affidavit.
Yes, my lord. By Monday, I will file affidavit, but my lord, no interim may be granted. Otherwise, the entire admission process.
No, my lord, I am not praying for entire process, my lord. Only one seat may be kept reserved. This is my interim prayer. I understand, my lord. I have never challenged the entire process.
Part is here you did learn it. PP Bora learn it. I think for the respondent of the. This petitioner article 26 of India, the petitioner has tried to direct the respondent or to include his name in the admin process
Lord, we have filed our additional affidavit today, in person to your lordship's order of 24/4/25.
Okay. I have just received a copy today, Lordship, a few minutes back. I have not received one.
Copy pona.
Let it come on record and Lordship can fix the matter on 9th of September if not inconvenient to this court.
Right?
9th of September, Lordship.
Part which side?
M das.
And M-DAS.
M das, Lordship.
Blood and bone.
Moment.
And with the proxy for the respondent number.
Respond number 1.
Respondent number 1. So for up.
SSA, my lord, there are multiple, with all the different respondent in all the cases. my lord. Only for SSA will.
Okay. Next the proceedings of that here 5. Affidavit. Additional affidavit.
Additional affidavit.
Pursuant to order of court dated 24/4/2025. Today and accordingly. No, today. Today.
Today, sir.
The learned court of it's not that the matter to be on 9th of
9th of
September.
September. Obliged, Lordship.
Item number 20.
Lordship, the learned advocate will appeal, Lordship. He's on his way, Lordship. He'll be here in a minute, Lordship.
Okay.
If the next matter is called, Lordship, maybe he should take the matter after the next matter, Lordship. He's on his way, Lordship, from court number 5.
Item 20.
May I please, Your Lord? And this concern of the petitioner, my lord, and earlier occasion, you sure my appeared, my lord.
You saw
And in the meantime, my lord, petitioner is also in a bedridden condition, my lord. It's an acute financial crisis, my lord. Basically, since 2023, my lord, he is retired, my lord. Till date, my lord, no.
the respondent after complaint.
My lord. That too, my lord, I will inform him, my lord.
Okay.
Item 21.
Lordship, till the last order, Lordship.
Anybody appearing for secondary education?
Number
21.
21, my lord, will lordship will give us 3 weeks time to file our. Yes, sir.
Instruction land.
Comes. Yes, sir.
Instruction.
Hardness.
J. Akhtar.
They after learned
Moment that
Sir.
to time local.
Posing, learn it. Mr. Kosik, learn it. Respondent, secondary education department, and right for drafting previous time.
Lordship, date may be given, Lordship. As a part
Into time.
it part has letter.
Update necessary aspects of respect
Oh, part has
progress.
letter. Part has letter.
That's it in the process.
Ajit Burman. Noenda.
In respect of inquiry, now then
22 Matai.
the information regarding total number of sanctions of grade 4 of Amra Higher Secondary School, Srivami district.
Next, what time now?
There is accordingly allowed recital
22.
method after 2 weeks.
Lordship, date may be
Get
given,
room.
Lordship.
Instruction.
Lordship, part had matter.
That's
Expedition. May it please your lordship.
Yeah.
In this case, I am appearing on behalf of His Excellency the Governor, that he is the chancellor of this particular university,
Yeah.
where the writ petitioner was appointed for a period of 1 year on probation. So they are basically aggrieved because we have withdrawn the appointment. If lordship is pleased to look at the appointment order, which lordship will find in my affidavit at page 24. Affidavit of his affidavit of respondent number 2 and 3, registrar of KK Hendik, Open State University.
page number.
Page 24. So this is the appointment order in favor of writ petitioner Dr. Jyoti Rekha Hendik.
Affidavit is dated 2nd of September 2022.
Lordship, just 1 second. It was filed in the month of August 2022.
23.
Yes. So page 24 is the appointment order. Have lordship got it?
Oh.
In fact, we have argued this matter. This matter was kept reserved for judgment also earlier. Of course, by a different court.
Page number 20.
4, Annexer B of my affidavit.
Yes.
So on 24 December 2020, lordship will kindly mark this date, 24 December 2020, the appointment order was issued. Recruitment to the post of professor in Hiranyo Chandra Bhuyak School of Science and Technology. This is under KK Hendik, State Open University. Your application dated 22nd December 2020. I am glad to inform you that you are selected for appointed to the post of professor in Hiranyo Chandra Bhuya School of Science and Technology under the general terms and conditions to be regulated by the KK Hendik State Open University Act 2005 as amended up to date, statutes, ordinances, and rules of the university in force from time to time and under the following terms and conditions.
name of the post, professor in so and so, nature of posting, nature of post permanent, scale is there, initial, scale lordship will also, that is also 1,44,000 to 2,18,000. That is also important factor here. Initial play as per KK Open University rules and provision. This is where the whole dispute is all about. Subject to the provisions of in the statutes, this appointment is made on provision for a period of 1 year from the date of joining. However, the appointing authority shall have the power to extend the period of provision. This offer of appointment may be withdrawn at any time during the provision based on administrative reason. We are harping upon this. This offer of appointment may be withdrawn at any time during the provision period based on administrative reason, which will be binding on you. So in the appointment order itself, we have said that you are on probation and it can be withdrawn if we have some valid grounds. And lordship will now come. This is the impugned order lordship will find at page. This one, huh? Page 50. Annexer I. This is what is put to challenge in the writ petition. On 16/3/2022, in pursuance to the decision of the 64th meeting of the Board of Management held on 8 December 2021, read with the provisions of clause B, Roman 6 and 7, under chapter 6 of the first statute of the university and the terms and conditions of appointment, the services of Jyotirekha G. Handik on probation as professor in Hiranya Chandra Bhuya School of Science and Technology, KK Handik University, is withdrawn. So we are withdrawing the appointment with immediate effect because of administrative reasons. That is number one. And number two, rejection of the UGC to provide recognition to BSc general program by letter dated 12/10/2021 in Hiranya Chandra Bhuya School of Science and Technology, KK Handik Open State University. So on two grounds we have withdrawn. One is administrative reason. Now I'll explain what are these administrative reasons. And the other one is that the university or that particular school of science and technology failed to get recognition of BSc general program. Why it is relevant? Now, if we look at the advertisement now, this is the first and the last state. Now let us first go to the advertisement. Page 17. This was issued sometime in the month of June or July in August 2020. Here, Lordship will see under the KK Handik State Open University, applications are invited from Indian citizens for the following post. Serial number 4, professor under Hiranya Chandra Bhuya School of Science and Technology, 1 post. And it is very relevant to apprise this honorable court that in this particular Hiranya Chandra Bhuya School of Science and Technology, there are only 2 disciplines. One is mathematics, the other one is computer science. These are the only 2 disciplines. Next page, Lordship will kindly come to page 18. Professor, serial number 4. 1 post, the applicant must have the following, must be of the following discipline: computer science and mathematics. These are the 2 disciplines, and the essential qualification A1. An eminent scholar having PhD degree in the concerned allied relevant discipline. Lordship will kindly mark this concerned subject, that means. And published work of high quality, actively engaged in research with evidence of public's work, etc., etc. And next page, an outstanding professional having a PhD in the relevant applied discipline from any academic institution, industry, who has the significant contribution to the knowledge of concerned allied relevant disciplines supported by documentary evidence. So this is the advertisement, and this is the first notice regarding the eligible criteria who can apply. In that institution, here itself said computer science and mathematics. Thereafter, a corrigendum was issued from where that misdirected approach of the authority has started to accommodate somebody. Page 20. By this corrigendum, which was issued subsequently, the last date was extended up to 5th September 2020, serial number 3. The last date of application of the above post has been extended up to 5th September 2022. The first advertisement said the last date was, it was 31st August. So one more week was given. But most interestingly, what has been diluted, serial number 2. The qualification to the post of professor under Hiranya Chandra Bhuya School of Science and Technology may be read as applicant must be from any discipline of science and technology. Earlier advertisement, the original advertisement said there are 2 disciplines, mathematics and computer science, and there the qualifications were required in the field of the concerned discipline. Concerned discipline means mathematics or computer science. Now, by this corrigendum, they have opened up, widened the participants. So, from any discipline of science, they can come. But there is an ulterior design. Why I am saying all this? There is a game plan. There is an ulterior design to accommodate somebody. Now, Lordship will kindly see the shortlisted candidates. Now, before that, I'll place the facts in my affidavit. Paragraph 4 at page 3. How the sequence of events had taken place. Paragraph 4. The deponent humbly begs to that an advertisement dated 14/8/2020 was published in Assam Tribune by KK Handig University calling for application for different posts, including one post of professor in so-and-so school. In the said advertisement, applications were called from discipline of computer science and mathematics. Subsequently, a corrigendum was issued in Assam Tribune dated 27th August 2020, stating inter alia that the qualification for the post of professor under Hiranya Kumar Bhuya School of Science and Technology may be read as the applicant must be from any discipline of science and technology. In the said recruitment process, the following candidates applied, namely Dr. Dharmaranjan Das, Dr. Jayanta Kumar Sharma, Dr. Ujjal Sharma, Dr. Jyoti Rekha Handik. On assessment of the applications by the expert, 3 candidates, namely Dr. Dharmaranjan Das, Dr. Jayanta Kumar Sharma, and Dr. Jyoti Rekha G. Handik, were shortlisted and called for interview, which was held on 22nd December 2020. It is found that the candidature of Dr. Ujjal Sharma was rejected on the ground of non-fulfillment of eligibility criteria, even though Dr. Ujjal Sharma had fulfilled the requisite qualification criteria for the post. His candidature was rejected for reasons not specified. The candidate had master degree in computer applications and also MPhil and PhD. So the actual qualified person, they have outstayed. 3 persons were shortlisted. One thing which Lordship I have not said, that this lady, the writ petitioner, she is working as a professor of chemistry in Dibrugarh University. She is from chemistry department. And this institution does not have chemistry. It has mathematics and computer applications. To accommodate her, they have diluted, they have digressed all the relevant provisions of recruitment. This is, then only the story will be complete. Now, the main person who was having the appropriate qualification or requisite qualification on computer applications with very high level of qualification, he was outstated before the interview itself. Because if he had participated in the interview, he would have got it because there is no other options, because he is the only candidate having this qualification. But anyway, that will unfold during my subsequent reading of the affidavit. Accordingly, the interview was held on the date and the selection committee recommended only the name of Jyoti Rekha G. Handik, that is opposite party, writ petitioner, who was appointed as professor under Hiranya so-and-so thing. Now, paragraph 5. The deponent humbly begs to state that on being approved by the Board of Management in its meeting dated 23rd December 2020, Dr. Jyoti Rekha G. Handik, the petitioner, was offered the post of professor in Hiranya Chandra Bhuya School of Science and Technology, while later dated 24th December 2020, on provision for a term of 1 year in terms of the K.K. Handik Open University Act 2005, the statutes and rules of the said university. We have quoted the particular condition regarding provision. C joined the said post on 1/1/2021 on lien for 2 years from Dibrugarh University. So C came on lien. Now, coming to paragraph 7. The deponent states that the Hiranya Chandra Bhuya School of Science and Technology has 2 disciplines, namely mathematics and computer science, which were duly approved and recognized by the University Grant Commission for Open and Distance Learning. In an earlier recruitment process initiated in the year 2019, applications were called from candidates of mathematics and computer science stream only. Surprisingly, in the advertisement under reference and under the leadership of the then Vice Chancellor Dr. Kondorpa Das, it was made open to the science stream, which, when the said school had no other subject in offering other than mathematics and computer science, with due approval recognition from the competent authority, that is UGC. It is found that Sri Dr. Jyoti Rekha Ji Handik is of chemistry stream, and the institution in question neither has any approval for the subject chemistry nor an approved course of BSc General till date. It is stated herein that it was the chairman of the selection committee, the then Vice Chancellor of Dr. Kondorpa Das, who conducted the entire process relating to the selection to the post of Professor of Hiranya Chandra Bhuya School of Science and Technology. This gentleman, he was working there without approval. He allowed lot of subjects to be taught, and finally he was to be dismissed from service. I'm just giving a background regarding Kondorpa. Stating the aforesaid facts, the communication dated 10/9/2021 by the Honorable Governor cum Chancellor of the University from the Governor's Secretariat was made to the Chief Secretary with the prayer to take necessary action in the aforesaid situation. So when the Governor, who is the Chancellor, he came to know about all these anomalies, that if institution does not have chemistry department, has recruited a professor of chemistry to teach mathematics or computer science, which is unheard in the present educational scenario or system. So the governor wrote to the state government that there are some serious anomalies regarding the recruitment process of this particular post. In the said letter, it was mentioned that in spite of there being a decision in the meeting of vice chancellors of universities of the state held on 18/12/2019, the recruitment of faculties have to be circulated through local Assam based Assamese and English newspapers, as well as 4 numbers of national newspapers, yet the same was not followed in the instant case. So they have narrowed down the persons who can actually apply by not giving advertisement in the national dailies. Further, the shortlisting of the candidates was not done in terms of the UGC norms, and the ineligible candidates were called for the interview by rejecting the eligible candidate, namely Dr. Ujjal Sharma, who had the requisite API score as per UGC and open distance learning experience. Apart from he is having PhD in computer applications. So he has the API score also. That is a parameter on the basis of which recruitments are done. The Honorable Governor was of the view that some vested interest was involved in not rejecting the ineligible candidates and selecting only the petition, that is Professor Jyoti Rekha Ji Handik, who is the wife of Professor Pratap Chandra Handik, Vice Chancellor of Guwahati University, and the same remains in the contention for the post before the selection committee. The whole intention was to bring her from Dibrugarh to Guwahati. We have stated, I'm not saying it from the air. That lady was working in Dibrugarh University in chemistry department. drawing a salary of 2,44,000. She came here to draw a salary of 1,80,000, but she wants the preference of posting, the place, location. That is the overall game plan at the cost of the institution. The institution does not need the chemistry department professor. The institution does not have that particular department. In spite of that, this lady was posted by outstaying the main person, that is Dr. Ujjal Sharma. We are not for Ujjal Sharma, but she is not entitled. So when the governor, being the chancellor, came to know, he wrote to the government, and government issued a letter to do the verification. In the light, next page, Lordship.
Is there any supporting document?
I am coming, Lordship. I have everything in this affidavit itself.
Okay.
In this affidavit, I am going systematically, Lordship, in chronological order. In the light of, one thing is very clear, that I do not have a car, but I am recruiting a driver. It is like that. They do not have a chemistry department and they are recruiting a chemistry professor. It is as simple as that. In the light of the above facts and circumstances, the Education Higher Department of the Government of Assam called for an explanation from the university, and on getting due response from the university and after deliberation, later dated 3/12/2021 from the Special Commissioner to the Government of Assam Education Department was communicated to the Vice Chancellor KK Hendik University, asking them to take necessary actions as per the statute of the Krishna Kanto Hendik Open University regarding anomalies in the recruitment of Jyoti Rekha Hendik. Further, anything beyond the records may be treated to have been denied and disputed. Annexer E, Lordship will kindly see. Annexer E to page number page 26. No, page 26, Annexer E.
Yes.
3rd December 2021. So, Special Commissioner to the Government of Assam Education, he wrote to the Vice Chancellor because the government received a complaint from the Governor, the Chancellor, regarding recruitment to the post of professor in Hiranya Chandra Bhuya School of Science and Technology, Guwahati. There are two references. May I read it? With reference to the subject cited above, I am directed to request you to kindly take necessary actions as per the statute of KK Hendik State Open University regarding anomalies in recruitment in respect of Dr. Jyoti Rekha G. Hendik as professor in Hiranya Chandra Bhuya School of Science and Technology, KK Hendik Open University. This has the approval of the Honorable Chief Minister Assam. And one copy was marked to PS to the Governor of Assam, who is the Chancellor. One copy is marked. Thereafter, the board of Management of KK Hendik University held on 8th of December 2021. Lordship will find that minutes at page 27, next page, Annexer F. Item number 1. Here. Directives given by Special Commissioner to the Government of Assam Higher Education Department. The Board of Management was apprised about the letter received from the Special Commissioner to the Government of Assam Higher Education Department via letter dated 3rd December 2021 regarding recruitment to the post of professor in Hiranya Chandra Bhuya School of Science and Technology. The same had a reference to an earlier communication to the Secretary to the Government of Assam dated 8/10/2021 that enclosed a copy of the letter dated 10/9/2021 from the Honorable Governor of Assam and Chancellor KK Hendik University requesting immediate action, necessary action for termination of the appointment of Dr. Jyoti Rekha G. Hendik as professor in Hiranya Chandra Bhuya School of Science and Technology. The matter was placed before the Board of Management for information and approval for compliance. After threadbare discussion, the board on principle agreed to comply with the directions of the Government of Assam and the Honorable Chancellor KK Hendik Open University. So two aspects they have considered. One, the directives of the government regarding the anomalies regarding recruitment of the appointment of the writ petitioner, and number two, the Honorable Chancellor's instruction. Resolution resolved that the directives of the Honorable Chancellor as per communication received from the Government of Assam later dated 3/12/2021 be complied with. The board has further resolved that legal clarity be ensured by the university on the language and content of the letter to be issued to Jyotirekha G. Handik, Professor so and so. So they have decided that she should be released because she was on probation. Her appointment was not confirmed. Therefore, there is no difficulty in releasing her. That's why we have said in our impugned order that her appointment has been withdrawn. She has not been discharged. She has not been terminated, withdrawn. Now, next will be, I'm coming back to the affidavit, paragraph 9. No, no, no. Mm. Mm. So, when this communication was issued or the minutes was issued, they have immediately challenged it before this honorable court. And there was an order that don't take the final decision of releasing. However, we have subsequently, we filed the interlocutory application and the honorable court was pleased to give us go ahead regarding issuance of the impugned order. That lordship will find at page 30. So they have challenged the communication given by the special secretary to the vice chancellor of the university. That order is at page 30. 8 and the order is at of 8th of December 2021. Immediately they came. May I read the second paragraph?
Okay.
These are because facts are coming out from these orders. The petitioner projects that she was appointed as professor under Hiranya Chandra Bhuya School of Science and Technology under the general terms and conditions to be regulated by K.K. Handik Open University Act 2005 on probation for a period of 1 year by communication dated 24th December 2020. It is submitted that at the fag end of the probation period by communication dated 3rd December 2021, respondent number 2 asks Vice Chancellor of K.K. Handik University to take action as per the statute of the said university on the ground that there was anomalies in the recruitment of the petitioner. Then next page, lordship will kindly see. Last line, last paragraph. As regard the prayer of interim, the court is inclined to provide that while there is no bar for the respondent authority to take action against the petitioner as per the statute, but no final order shall be passed until further orders from of this court. So there was a restraint order from the court regarding issuance of the final order in terms of the decision taken in the board meeting by resolution number 1. Thereafter, the honorable court on 15/3/2022, page 32, we have filed an interlocutory application, and while disposing of the interlocutory application, this order was passed. Page 33, it starts basically the same thing. Repetition, paragraph 3, 4, all these are. Now, our stand also we have stated. There's a very long order by which the honorable court allowed us to go ahead. Then I'm not taking your lordship to all the arguments, but tentatively the honorable court opined that paragraph 22. Although these observations are not binding on this honorable court, but the prima facie view expressed by one of the learned single judges. May I read it, lordship? Paragraph 22. In the consideration of this court, what is crucial importance is the reason behind the contemplated action. Admittedly, chemistry is not a subject approved by UGC for the K.K. Handik University, and therefore the very process of recruitment of the writ petitioner for a subject which is not non-existing is not only erroneous but wholly illegal. While the issue of such initiation of recruitment is not an issue before this court to be answered, the action of the K.K. Handik University in making recruitment of a non-existing subject at the cost of public exchequer would perhaps require serious introspection and also enquiry. This court is unable to accede to the submission made that the services of the writ petitioner could be utilized for preparing of SLM. That is some study materials. When the writ petitioner does not meet the basic requirement of being duly inducted teaching faculty, such submission is absolutely liable to be rejected. So the Honorable Court in this paragraph said that her appointment was illegal. Next paragraph. It is, however, required to be clarified by this court that the aforesaid observation regarding illegal recruitment is not against the writ petitioner, though she is the beneficiary of such illegality. This is because of the fact that no fault can be attributed to a candidate who responds to a notice for public recruitment. Moreover, it is not because of any false shortcoming or misconduct on the part of the writ petitioner, which appears to be reason behind the impugned notice dated 3/12/2021, but because of the sheer administrative reasons, namely recruitment made for a subject without such subject being approved by the UGC. This court is also conscious of the fact that the order of appointment of the writ petitioner is dated 24/12/2020, and she had joined on 1/1/2021 as revealed in paragraph 3 of the writ petition. In that view of the matter, the period of probation has otherwise come to an end, and in view of the fact that there was no discernible material to impute any misconduct on the part of the writ petitioner, the discontinuation can be deemed as a termination simpliciter on expiry of the period of probation due to administrative reasons. Under the aforesaid facts and circumstances, this court is of the view that the interim order dated 8/12/2021, by which an embargo was imposed regarding passing of final orders pursuant to the impugned notice dated 3/12/2021, is liable to be vacated, and accordingly the same stands vacated. It is, however, made clear that any action would be subject to final outcome of the writ petition. So interim order, which was passed to restrain us, has been removed by this order. And thereafter, we issued this order was on 15th of March 2022. So thereafter, we issued the impugned order, which Lordship we issued in the next date, page 50. So, and thereafter they have withdrawn that writ petition and a fresh writ petition was filed here. One important aspect is that while we have recruited this writ petitioner lady to do some administrative work and etc., there was an effort of the university to take approval for general stream of BSc, which should have included chemistry as a subject. But that was also rejected by UGC in the month of October 2021. Now, coming to paragraph 12, page 10. The deponent has no comments to offer so far as the same was matter. However, anything beyond the records may be treated to have been denied and disputed by the answering respondent. Further, the deponent begs to state that after the appointment of the writ petitioner, pursuant to a decision of the Academic Council in its meeting held on 30th July 2020 and 19th June 2021, under the direction of the then Vice Chancellor, the university, amongst others, on 31st of July 2021, submitted a proposal before the University Grants Commission in the portal for granting approval for offering undergraduate courses in science, combination of 3 subjects, including chemistry, under Hironya Chandra Bhuya School of Science and Technology, and subsequent thereto, submitted hard copies of application on 5/8/2021. After due scrutiny by the UGC on 12th October 2021, in the portal of UGC, it was shown that UGC has refused to approve BSc courses due to self-learning materials not being ready. This lady was given to prepare self-learning material. That was also not done. I am not on that. But what is important here is that the university or that particular Hironya Chandra Bhuya School of Science and Technology, they wanted to get approval for starting the undergraduate courses in science, which includes chemistry as one of the subjects. But that was also rejected, and that I have stated, and the document Lordship will find, it is there, page 44. Here, page 44 starts. Expert Committee's Interface Meeting Assessment Format, ODL program. So it starts from there. Lordship will find a relevant portion at page 49. Recommendation summary. Bachelor of Science, combination of 3 subjects, which includes chemistry. And the remark column, it is not recommended. So the UGC did not approve this particular course. That is Bachelor of Science at the undergraduate level, which have chemistry as one of the subjects. So absolutely there is no work for her. So in my humble submission, then Lordship will kindly come to paragraph 15. This paragraph 15 and 16, I would like to say. As regard the statements made in so-and-so, the deponent denies the averment made by the petitioner, humbly begs to submit that pursuant to the order dated 15/3/2022 in IS so-and-so, the university issued the office order dated 16/3, whereby the services of the petitioner as Professor of Hiranya Chandra Bhuya, School of Science and Technology under KK on probation was withdrawn with immediate effect due to administrative reasons and also because of the rejection of UGC to recognize BSc General Program. Next page, paragraph 16, regarding the provision part we have stated, the deponent has no comments to offer so far as the same are matters of record. However, anything beyond the record may be treated to have been denied and disputed by the answering respondent. Further, the deponent begs to state that the whole concept of provision is to judge the suitability of the candidate appointed to a particular post. It is well settled that generally a probationer does not acquire any substantive right to the post and cannot complain if his service is terminated at any time during the probationary period, that is before confirmation. It has been pointed out that a probationary appointment is by nature of transitory character, and in the absence of any special contract or special rule regulating the condition of service, the implied term of such appointment is that it is terminable at any point. But it has to have a justification. We are justifying because one is that the university or this institute does not have chemistry as one of the discipline. Number 2, we applied for BSc course that was also denied by UGC. So absolutely there is no work. And she also knew it very well. She did not resign from Dibrugarh University. She came for 2 years lien. Now when they fail to get any interim placement, she is working in Dibrugarh University for last 2-3 years. It is not that her right has been.
Now she is in Dibrugarh.
She is in Dibrugarh University. Unless she has retired, I do not know her age. But if I think still 65, so must be working. May I continue, Lordship? Page 14. The period during which an appointee has to be on probation is normally provided by the service rules or the order of appointment. In the instant case, the terms of conditions of the petition for in the instant case, the terms and conditions of probation service was alluded in the appointment order dated 12/20/2020. The petitioner in the instant having accepted the terms and conditions stipulated in the appointment order and allowing the period for which she was appointed to have lapsed either by efflux of time or honorable court's order, it is not permitted to turn back and say that the terms of conditions stipulated in the appointment order are not valid. Though the appointment of the petitioner on probation was tainted with favoritism, withdrawal of her service on probation was founded on grounds of administrative reasons. Post-recruitment period arising due to rejection of proposal by UGC for the proposed program BSc General. Such right to withdraw of services was derived from the appointment letter of the petitioner. See, in our appointment order itself, later we have indicated that because of administrative reasons also we can withdraw the appointment on probation, serial number 4. Thus, in the instant case, falls under the exceptions to the principle of natural justice as the withdrawal of service was based on valid reasons. The petitioner was appointed on probation, and in the appointment order, it was clearly mentioned that her provision service conditions shall be governed by the provisions of the statute of the university. Furthermore, it was mentioned that the offer of appointment may be withdrawn at any time during probation period based on administrative reasons which should be binding upon her. Thus, when the appointment order has stipulated administrative ground as one of the basis for withdrawal termination of services of a probationer, the fact that the petitioner's service was terminated on administrative ground by specifying the reasons and not saying anything more cannot be considered stigmatic or punitive for violating Article 14 and 16 of the Constitution. So there is absolutely, in my humble submission, it is not a stigmatic or punitive order. It is a order simpliciter. So these are the facts which is basically relevant for the adjudication of this dispute. So my humble submission on the basis of, and one more thing in the writ petition itself, paragraph 1, paragraph 2 of the writ petition, page 5.
Yes.
Second paragraph, she has stated, the writ petitioner humbly begs to state that while she was serving as a professor of Department of Chemistry, Dibrugarh University with a brilliant academic career to her credit, having nearly 27 years of teaching experience, and also served the Dibrugarh University as a director honorary in educational multimedia. So she is working in Dibrugarh University, and she is on lien. That is also, that can be discernible from one of the documents which আছে statute language. She has come on lien for 2 years. That also I have found, I am missing it now, Lord. I'll place that also. She is on lien of 2 years. When she joined, কিন্তু আমার একটু ডিফিকাল্ট আছে বলতে ইয়াতে কোনটো রিলেভেন্ট So, chapter 4 of our statute. Chapter 4. This is a part of the Act and the statute. So, may I read? Manner of appointment B. Lordship will kindly come to next page, Roman 7. 6 and 7. The appointment in all posts shall be on probation for a period of 1 year, extendable by a maximum period of 1 year more in case of unsatisfactory performance. So we have the Vice Chancellor will decide upon the confirmation at the end of the statutory period of probation. So we have that power to assess whether her service is required or not required. So what we have done, it is in terms of the provisions and the power given under the statute, that the VC can take a call at the end of 1 year. So she had joined on 1/1/2021, and the impugned order was issued, should have been issued actually before 24th, but we had issued it on 16th of March because there was an embargo created by the Honorable Court's interim order passed on 8th of December 2021. My Lord Justice Surana's order. So we filed a vacating petition. Finally, the vacating petition was disposed of on 15th of March, where we are given the go ahead, and on 16th we have issued. So it has to be considered as within 1 year we have issued it. She has not got any extension also. And if Lordship is pleased to take my affidavit at page 5. Page 5. Page 5, the middle paragraph. She joined the said post on 1/1/2021 on lien for 2 years from Dibrugarh University. So I am not on salary, but she was earning about 60,000 more in Dibrugarh University. Her salary was, she has stated somewhere, 2,44,000, whereas we are giving her 1,80,000 here. So in no way, Lordship, her fundamental right is deprived or infringed upon. She knew very well when the appointment order was given to her that she will be on probation. And at the end, we can take a call on administrative reasons to withdraw the appointment order. We have two grounds. Her initial appointment itself, Lordship, is very clear that without having a chemistry department, we have recruited a person from chemistry background. Number two, while she was in service from June, July, we started the process to get approval from UGC to start a undergraduate BSc course with chemistry as one of the subject on 21st of October 2021. Before, at that time, she was 8 months in service. On 21st of October 2021, which I have just placed, Lordship, that the UGC has denied giving recommendation to start that particular course. So there is no scope once her period of 1 year probation is over that she can be accommodated in any particular specific work for which she has the expertise. Her expertise in the Department of Chemistry. We do not have a chemistry department. It is as simple as that. In that view of the matter, we have the every right to discontinue her service by giving her a withdrawal order without any stigma or without any bad name to her career. And she has happily gone there, happily or unhappily, I do not know, but she has a steady job in place in Dibrugarh University. And the whole design, I do not want to delve much depth. The Vice Chancellor, Dibrugarh Guwahati University, is her husband. The same department's person is manning the KK Handig University, who had the reputation of running 23 unapproved courses, while he had only 8 departments under KK University. 15 disciplines he ran without approval of UGC. About 40 crores misappropriation, that is one. It was raised in the assembly, and about 7,000 or 8,000 students' career was doomed because they did not pursue a course which is approved by UGC. My Lord Justice Aftab Hussain Saikia's commission was there. He found out all the anomalies, and this is one gentleman, KK Hendricks, Vice Chancellor. He was removed from service. No Vice Chancellor prior to him in Assam was removed or dismissed from service. So he, along with the Vice Chancellor of that time at Guwahati University, the wife of Jyoti Rekha Hendik, he was having the same department, same university. They designed this whole thing. It has come out. We have said tainted, favoritism, everything. If Lordship gives a direction to do an inquiry, we can find it out. But one inquiry was already done by my Lord Justice A.S. Saikia of this Honorable High Court. He found a lot of anomalies in the action, in the activities of the persons who was the head of this selection committee. He was a Vice Chancellor. It is apparent, Lordship, we don't have to delve much. When I do not have a chemistry department, why should I bring a person with chemistry background? So this is my humble submission. There is absolutely no merit in this case. No student can be given exposure to any teacher who does not have the expertise in that subject. What are these subjects? Mathematics. What are these subjects? Computer applications or computer science. So a chemistry person cannot teach. In the day, nowadays, everything is so specific, so specialized. When we have the scope of specialized person, in history, there are 3 different things: ancient history, modern history, and medieval history. If I belong to ancient history, I cannot work for history department in the other 2 segments. That is the norms set by UGC. And here, mathematics students are being attempt has been made that the chemistry teacher will teach mathematics students. This is the plight.
So when
So
the
it-
corrigatum was issued,
Yes,
whether it was with approval from the Board of Management.
that one, Lordship. That I have to find out because I have to have a lawyer from that university now. I'm representing the chancellor, the corrigendum. The corrigendum language in reference to advert the following changes are made. There is no reference to any decision.
Okay.
Even if you suppose assume that approval has been granted, but the same board has now taken a decision to remove her.
Okay.
Same board. We are assuming, I'm not assuming. In fact, I don't think, and on guesswork, I should not make a submission also. But suppose let us assume that this board has given this right to issue the corrigendum by widening the area of persons who can apply. That means diluting the eligibility criteria. Suppose they have done it. Now, after 1 year, when they have failed to get the approval from UGC to start suppose there is a attempt that let us include her as a chemistry professor in our college. And in the meantime, before the probation period is over, we will get approval to start BSc Science with chemistry as a subject. Then their whole attempt would have been successful. Then I would not have a case here. That was also tried from the month of June, July. And in October, the proposal was sent. I have placed the proposal also. The proposal was sent on 16th of June and 31st of July. And the UGC gave their opinion on 21st of October 2021, when she was in her 8th month of probation. So that attempt also they have failed.
Okay, but is it not a continuous process? This year they have failed to recognize it. Next year they may recognize.
No. That subject was never introduced. For the first time they tried. Oh, for the first time, it is not that every year. Suppose they have a mathematics and this computer science. For that they want renewal. But here introduction of a new subject, new course, not subject. May I place it once more, Lordship? Page.
Number 49.
Page 49. Bachelor of Science, combination of 3 subjects, not recommended. Not renewed, that is not the word, not renewed. And if we go to the corresponding paragraph in the pleadings, I can take your lordship to that pleadings where we have stated that. Yes, paragraph 12, page 11, lordship will kindly come to further, third line, page 11 of my affidavit. Further, the deponent begs to state that after the appointment of writ petitioner, pursuant to a decision of the Academic Council in its meeting held on 30/7/2020 and 19/6/2021, under the direction of the then Vice Chancellor, the university, amongst other, on 31/7/2020, submitted a proposal before the UGC in the portal for granting approval for offering undergraduate course in science, combination of 3 subjects, chemistry, general, etc., under Hironya Bhuya so-and-so, and subsequent thereto, hard copies where applications were submitted on 5/8/2021. After due scrutiny by the UGC on 12/10/2021, in the portal of UGC, it was shown that the UGC has refused to approve BSc courses due to self-learning materials not being ready. That means for the first time, they tried to introduce it. It is not for renewal. They wanted to just to accommodate a particular person in Guwahati. These are the exercises they are doing. And they are doing it without having proper resources. So how public fund, and we trusted these people. When a person is at the stature of Vice Chancellor, everybody trusts them. We have lot of hope, lot of expectation from the society. The same gentleman who was removed, who was dismissed from service, he initiated this move to start a new course just to accommodate, to please his senior's wife. And these are, I am saying, not from my personal knowledge. Everything is on record. And that is why the government of Assam issued that notice to the vice chancellor after the governor receives lot of complaints from their own fraternity. It is not that the governor or the state of Assam are looking after and doing these minor roving inquiries. Highly obliged, Lordship.
Yes.
I have two citations and a written arguments, Lordship.
Yes, yes, you can.
I can give two judgments on the confirmation part and the natural justice part.
Lordship, can we submit a reply on 9th, your lordship? 9th of September, your lordship.
9th of September.
Lordship.
Okay.
Half an hour, lordship.
Heard, Mr. Your good name.
I'm N. Gautam, lordship. I'm for the petitioner, your
For
lordship.
the Advocate General of Senior Advocate, assisted by Mr. P. Chaudhary, Learned Counsel for the respondent. Heard in part, place the matter on 9th of September.
Lordship.
Lordship, out of time, I'm sorry, Lordship. So for the item number 23, let's I pay for little accommodation, Lordship. Another day, Lordship. Item 23. Today I have some difficulty, Lordship.
Okay.
Deeply obliged.
My lord, I may be permitted to mention item number 38, my lord. In this case, my lord, they have filed two counter affidavit, my lord, stating that they have filed review petition, my lord, contempt matter, my lord. So may I pray that they may come up with a number, filing number, as well as the date, and a copy be supplied to me on Wednesday, my lord. That may kindly change.
Yes.
On 3rd of September.
Since they have not filed it.
They have
I have filed it, my lord. Today morning I have filed it, my lord.
Okay.
But there is a wrong statement in the affidavit, my lord. I mean,
date is wrong, there may be. That's why, my lord, I have.
The
date was wrongly typed as 20.
actually today I have filed it.
That's why I'm filing. Filing number as well as the copy, my lord.
Mr. Antonia, you want to take it back?
Yes, I want to correct the date, my lord.
That is,
if a lawfully accepted, then we don't have to correct. If my friend is also there.
file has not come, my lord. Petition has not come up. So I've seen the record.
No.
They will correct it. I have no objection to that.
No, but this, that is not the procedure.
Yes.
It
is up to your lordship.
notification, you have to go by that.
Yes.
In that case, my lord, I can refile the affidavit, my lord. I can withdraw the.
Only thing that we have mentioned it wrongly, the date of filing the review. It should have been today, lawfully, it was written as 20. That is that.
Just so you file it correctly, you take it back.
Yes, my lord.
Yes. Then lawfully kindly give us.
Or Mr. DK Mansuri, for the petitioner, and Mr. SMP Sisri, and Mr. Katunia. Respondents.
With positive, my lord, filing number.
Mr. Katunia submits that he has filed the affidavit today morning, but some error in respect of the date perhaps therein, and as such, he may be permitted to take back the same and to file a fresh one. There is accordingly allowed. Mr. Katunia to file the affidavit on
Day after tomorrow, my lord.
day after tomorrow, and this is the list the matter on
3rd.
3rd of September.
3rd September. They will take a copy of the review petition.
Yes, my lord.
But they have stated.
I will serve a copy of the reviews tomorrow, my lord.
Okay.
Not tomorrow, on tomorrow maybe. I'll collect.
Also the review petition.
Masha bhai.
এখন পুরানো নয় মোটা আছে এখন কিন্তু তার ভিতরে লেতে নিয়েছে
ভিউটো দিলে এপ্ৰুভেল নহয় ভিউজ অফ অপেনিং GPF
But here I am praying for some time, my lord, to obtain the latest status. Well, may take it up next week, my lord. Next week.
My lord, that may be.
I am a product bill and Mr. Custodian for the in elementary education department. It's open.
I am for respondent number 4, your lord.
And number 4 and Mr. B. Sharma for
Corresponding number 3, my lord.
part 3.
3, count engine.
Said Custodian submits that in the day granted time to obtain correction. It is accordingly allowed to submit correct on COVID accepted.
Obliged.
Obliged.
May it be pleases your lordship, on behalf of U Sharma, your lordship, he is, due to some personal difficulties, he could not be able to attend the second half, your lordship. So, your lordship, I'm praying, your lordship, kindly some accommodation may be given, your lordship. List this matter after 2 weeks, your lordship.
Some of his close relatives died,
Ex-
lordship. That's why
expired.
he has left the court, lordship.
He was very much present in the first half, your lordship, but due to some
Whether somebody heard the matter
My lord,
earlier,
the earlier, my lord, it was heard before Honorable Justice Michael.
but after it was released,
My lord,
it was released.
not part heard, my lord.
no, not part heard, your lordship.
Not take it part heard, my lord.
Just pleadings completed, your lordship.
My lord, previous completed hearing was also conducted. One order, my lord, can we see? The order dated 18. The order dated 18/3/2025. Thousand 20 matter, my lord. So a short date may be given because otherwise, well,
2 weeks time may be granted to us,
weeks
your
were
lordship.
too long, my lord.
Our Islam learned from record of the people. Also heard next leaders learning from the we have starting for the secondary education department.
Give for respondent number 3 and 4.
Learned or 3 and 4. Miss does learned council submits that Mr. Sharma account of some medical emergency that record devices and surprise for why 2 weeks required?
Yes.
After
Total
1 week. Yes, sir.
According to this provided that it's a matter of 1 week.
A date may be given.
Can it be on 6th, your lordship? 6th.
6 is the Saturday.
Saturday.
Saturday. Much.
Then Thursday. Thursday. Thursday long, huh?
May it please your lordship. In terms of the order dated 3/1/2025, your lordship will kindly peruse the order dated 3/1/2025.
Yes.
May it be pleases you, lordship. On the earlier order,
Your
your
lordship,
lordship,
I am the petitioner. I may be allowed to make my submissions. If she has some instruction, let her place it. No issue.
I have instruction, your lordship.
Then let her place it. Copy to be furnished to me also, your lordship.
I'll give that soft copy.
I am not aware what she has placed it, your lordship.
और बेटा कॉपी ले आइए आपके पास डिटेल्स इंस्ट्रक्शन
My instructions are that we have already submitted whatever is there.
Your Lordship, yesterday, Your Lordship, we have telephonic conversations with the concerned authorities, and as per their submission, Your Lordship, I have this instruction along with me, and there it is clearly stated that I would like to read it, Your Lordship. With reference to the subjects stated above, I with due honor inform you that the office of the undersigned communicated with the petitioner to comply Honorable Guwahati High Court order dated wide 9/2/2025. Although the petitioners yet not submitted any relevant documents in this connection, hence it is prayed to directed the petitioner to submit the relevant documents as early as possible. It was from their side, Your Lordship, it was kept pending. And I would like to produce the earlier order dated also, Your Lordship, that is 9/2/25, where it was clearly instructed, Your Lordship, to produce relevant documents, Your Lordship. And it was fresh instruction, Your Lordship, dated on 27 August 2025 from the concerned department.
That order is already there in your record. Your Lordship may kindly turn to page order dated 3/1/2025. So come down to all the records. Has your Lordship got it?
Near guess.
3/1/2025. The court by its order dated 4/12/2024 had recorded the submission of the Learned Standing Council, Elementary Education, the DEO, Kamrup, Amengaon, such and such, have already submitted necessary proposal along with the relevant documents with regard to the area salary proposal of the petitioner to the jurisdictional inspector of the schools for taking further necessary action. Today, when the matter was listed, such and such Learned Standing Council, Secondary Education on instruction, submitted that the proposal as submitted was reverted back by the Director of Secondary Education Assam in view of the fact that 13 were not enclosed to the said proposal. On a query made by the court, Ms. Das, Learned Standing Council, Secondary Education has submitted that the following documents are not found enclosed in the said proposal. Those were this 1 to 8. These documents are not supposed to be with me, Your Lordship. These are supposed to be in their own records. In view of the above submission position, it is hereby directed that the petitioners herein approach the jurisdictional inspector schools under whom they are presently serving and submit the documents so indicated herein above, if the same is available with them. There was a categorical direction. If the same is available with them, the jurisdictional inspector of the school shall also collect the remaining documents from the concerned school authorities, and thereafter, within a period of 15 days from the date of submission of documents by the petitioner, submit a proposal complete in all respect to the director. Your Lordship, we don't have all the documents, and there was a categorical direction from this honorable court. If those are not there, you need to collect it. The officials are required to collect it and place it on record. So whatever we could collect, Your Lordship. So thereafter, we submitted on after 12/3, we submitted whatever we could. First of all, they have not accepted our documents. Secondly, when they have accepted our documents, they have not given any receiving to us. So where do we go, Your Lordship? And these documents are supposed to be with them. This is unnecessarily, they have taken it as an ego herself. Don't pass comment, please. Huh? I'm making my submission, you hear it.
No, Mr.
I have not passed,
no.
I have not uttered any words.
Yes.
So my humble request, humble prayer before this honorable court is that in terms of 3/1/2025, either the inspector process with the entire things or he should be called to the court, Your Lordship, because there are two things. I have tried my level best to give whatever documents are there with me. After handing over the documents to the dealing assistant, they are not giving me any receiving of the same. So where do I go, Your Lordship? And the court has categorically stated, Your Lordship, if the same is available with them, if the sames are not available with them, the inspector has been directed to collect it.
Where is that order?
Your Lordship will come to page, the order dated 3/1/2025.
Which part?
Your Lordship.
Which part?
First, second. The page number 5, Your Lordship, the internal page.
The 3 pages are there.
No, it's a 3/1/2025 order, Your Lordship.
Yes.
It's in the part of the, It's in a part of the record itself. The order dated 3/1/2025.
No, it is part of the record.
The order passed on 3/1/2025.
Yes.
In view of the above position, Your Lordship.
Yes.
Has Your Lordship got it? In view of the above position, it is hereby directed that the petitioners herein would approach the jurisdictional inspector of schools under whom they are presently working, serving, and submit the documents so indicated herein above, if the same is available with them. So there is a categorical direction if the same are available with me. If something is done, the next para, Your Lordship, the jurisdictional inspector of school shall also collect the remaining documents from the concerned school authorities. And thereafter, within a period of 15 days from the date of the submission of documents, by the petitioner, submit the proposal complete in all respect to the Director of Secondary Education. Your Lordship, the documents which they have said, Inspector of Schools forwarding letter, these are not supposed to be with B, Your Lord. These are the official documents. And the court knew it very well, and therefore the court has passed this order. But in spite of that, whatever documents I could collect, I have given them. Of course, I could give all those documents after 12/3/2025. That I must admit. And therefore, on 2 occasions, I sought times to submit the document. But they are not giving me a receiving copy. They are just harassing me for the purpose of.
You have parted all the 8 of.
No, I could not service all the documents, whatever documents I had with me, as per the direction of the court. The court has said it very categorically.
You tell me what are the documents you have parted to the inspector?
As per my instructions,
The documents means what document?
this listed as 1, 2, 3, 4 up to 8.
Yes.
Whatever the documents are there with me, I have submitted, Your Lordship.
Which one?
Which document you have parted?
As per they said me that that non-royal certificate, then service book, appointment letter, and few others, whatever I have. I cannot that to that effect I have to ask once. But to me,
You obtain or seen a learned counsel for the learned order right. The it's have submitted the documents indicated as page number. Some of the documents that some of the documents as indicated is number 1-8, but it not the definition of the document. The subject.
Your Lordship, otherwise also the court has directed, even if I have not submitted it, they'll proceed with it. They are keeping it pending for unnecessarily, Your Lordship. Only this is a view to harass me. So that direction may be given to them. Whatever documents I have submitted is there with them. Even if I have not submitted.
What then further not with you. According by the obtained, their instruction the petitioner further the document they have submitted the matter on next.
Lord, I appear for a number 4. I'm appearing for secondary education.
Not for
Oh, 9.
listen.
Your Lordship,
I'm
can
deeply
you be a bit
obliged.
ahead of it on 8th of September because I have to take that instruction. I'm deeply obliged, Your Lordship.
May please, your lordship. My lord, hearing this case, my lord, the petitioner before lordship. My lord, he was appointed as a library assistant by college authority, college governing body in the year 2006. At that stage, my lord, the college was census stage. And while the provincialization has been made, the service of the private respondent who was never served in the post of
Yes.
my lord, private respondent never served in the post of library assistant has been provincialized as a library assistant. Lord, you will find the impugned order of provincialization at page 43. Babul Hussain at serial number 5, private respondent.
Yes.
My lord, page 43, serial number 5, Babul Hussain, general category caste, appointed provincialized is library assistant, and his date of joining, Lord, you will find in the last but two column, date of joining, under date of joining column 9/12/2006. My lord, I was appointed by resolution, Lord, you will find in annexure 5, page 36. That was resolution was updated 11/3/2006, and by resolution I was directed to be appointed, and my appointment letter at page 40 issued by the Secretary, Jonopriya College, Baniarapara, Secretary, Jonopriya College, Baniarapara. It was of 15/3/2006, and I joined on 16/3/2006, page 41. My lord,
What is the appointment order?
My lord,
But
my
appointment order is a paper.
my appointment, my lord, at page 40, 15/3/2006, as a library assistant of Jonopriya College, Baniarapara, on consolidated pay as deemed fit by the governing body of the college with effect from GB Resolution 2A dated 11/3/2006. This is the appointment letter, and accordingly I join in the next day on 16/3/2006 at page 41. Principal has endorsed my joining report, page 41. The principal also subsequently issued certificate that I am working continuously. The certificate at page 42, 16/5/2011. I have certified that I have been working as a library assistant at Jonopriya College since 16/3/2006 till now. His character and conduct are found good. Then my lord, provincialization order. And lordship may kindly have a look at page 45. This is a staff pattern report of non-teaching staff. Here, my lord, under serial number 2, sub serial 5/3, Babul Hussain, his name is there. Under the category of column 3, his post is junior assistant. This is staff pattern prepared by the principal. He is junior assistant, and under column 6, his date of joining also, date of appointment is also shown, 6/12/2006. Sorry, date of appointment 6/12/2006, and date of joining under column 8, 9/12/2006. So, my lord, from the for taking into account of the date of joining, he is also junior to me, and his in post was junior assistant.
not library assistant, but he has been provincialized in the post of library assistant. My lord, law has, my lord, clearly said that for provincialization of any post, the incumbent is to render service at least 6 years. My lord, that is the law, my lord. He never served in that post, my lord, in the library assistant. Lordship may kindly have a look at the provision. Section 4, subsection 2, subsection 2, 3.
Of which act?
My lord, it is the provision of Assam Education Provincialization of Services of Teachers and Reorganization Educational Institution Act 2017. Section 4.3, 4, my lord, 4 to Roman 3. Teachers and or tutors to be government servants. Lordship got it?
Yes.
My lord. I am referring, my lord, subsection 2.3. My lord, 2 starts like that, my lord. Teachers and or tutors to be provincialized under this act must have been working as a teacher in the concerned Bansar educational institution as mentioned in section 3.1 Roman 1 that have been recognized by the competent authority on or before 1/1/2006. And then 2 must have minimum educational and qualification, professional qualification. Then 3, my lord, must have rendered at least 6 years continuous service as on 1/1/17 from the date of joining in the concerned Bansar educational institution, which must be on 31/12/2002 or prior to that. My lord, this has clearly mentioned that the particular incumbent have to render 6 years service in that post only. He may be considered for provincialization. He never served in that post, the private respondent. But he has been provincialized, depriving me. That is my case, my lord. And
Where is his appointment?
my lord, his appointment order, my lord, there was earlier litigation, and that earlier we have filed another writ petition, Annex 15. In that case, my lord, the direction was issued to file an appeal, and we file appeal.
No, in the present case, where is the document?
My lord, in the impugn provincialization order that has been provincialization order itself, my lord, in page 43, page 43, my lord, in exercise of authority conferred under provision of so-and-so, the service of the following employees of Jonapriya College.
His date of joining is 9/12/2006.
2006.
Yes.
So he has been provincialized.
Provincialization order was passed on 6th of February 2020.
Yes, my lord. My lord, we have challenged it by another writ petition, and that writ petition, my lord, was disposed of by order. Lordship will find in Annexure 15, page 82. This was disposed of with a direction to.
No, we are not concerned with that order. You show me the document. Where is the document?
My lord.
Then in one capacity, he was appointed.
My lord.
That was, my lord, that order is in my IA, my lord, page
My lord,
78,
my lord, there has been another order.
page 78.
My lord, that is to be looked into, my lord. File an appeal. Appeal was dismissed, my lord. In order to
Page 78, annexure 12.
that I have shown, my lord, in page 43.
My lord got.
No, because appointed, his service was provincialized as library assistant.
Yes, my lord.
But in what capacity?
Oh.
That order.
That is in page 23 and 24 one. 23.
Page number.
Yes.
I.
I.
23 is my appointment. Or 20. No. My lord. These are not of private respondent, my lord. One is
A private respondent, mine is 19. Appointment is 18. Joining is 19. My lord, type copy is 17. Annexure 1. My lord got it. Yes.
So you have been appointed as LDA.
Yes.
And but your service has been provincialized as library.
Yes, ma'am.
It permits it. It permits it.
Yes, my lord. All are same category post, my lord.
Maybe.
No, I did not. My lord, I'll. When I submit, I'll prove it before this honorable court that I did not occupy his placement.
So how do you justify that being appointed as LDA to service is provincialized as library?
My lord, all these posts are of same categories, my lord. When considering the seniority of LDA as well as, my lord, when the provincialization aspect came, my friend who is now making a submission, he was not there in the fray for that library assistant, man. I'll prove it.
my lord.
It's only that, my lord, heartening that when he lost the bus, now he has reverted back. His friend, if he's, I think he has not finished, my lord. Let him finish.
Okay, the difference of clause 3 of the post.
That is for teaching and that is for only the teachers and tutors. I think my lord is looking at the 17 Act.
Yes.
17 Act is not applicable. It is the 18 Act, non-teaching staff.
Of 18 Act.
Yes, it's 18 Act. 18 Act is there for regarding the non-teaching staff provincialization one.
Which section provides it?
My lord, actually, these posts are actually governed by the Assam Ministerial District Establishment Service Rules. grade 3 posts are, is not, the service conditions are not governed by this. It is just the formulation, my lord, who will get appointment. But ultimately the grade 3 are covered by, and it is under the provisions of the Rule 7 of the 1967 rules, that is Assam Ministerial District Establishment Service Rules, and Rule 11 over there is the question of seniority comes, my lord. Well, the only thing at this juncture, I would only say that what my friend is saying before this honorable court, my lord, is absolutely misleading, my lord. If my IA is my in front of my lord, then only one document I'll show, my lord. Annexure 10, page 68. And I think perhaps this is the reason. I think they are the one who will say, my lord, why not provincialized? Annexure 10, page 68.
Yeah.
My lord has seen a format, my lord. My lord, other than the elementary education, when it comes to the secondary as well as the higher, every individual who's asking for the provincialization of the service, they have to submit this individual forms, my lord. Over here, this is filled up by the writ petitioner himself. It's not my document. This is a filled up document when they are required to submit the forms for provincialization. Let us see in the second column. My lord has seen it. Second column. He's not asking for library assistant. He was asking for assistant librarian. Now, see the qualifications. My lord has seen it. My lord, see the post graduation is from CMJ University. Then
Not CM,
CSJMU, my lord. Then Bliss is from Vinayak University. And then Masters of Library, that is from MKU. I've given the details of all these universities over here. Is only that, my lord, when this honorable court, in another case, when it declared that all the off-campus decrees and Binayak was mentioned, it will be not recognized as a degree over here. Then only he turned around and he said, no, I'll go back to my original post. But before that, his appointment was already there as a, not library assistant, as assistant librarian, his appointment is there. And if your lordship looks at the page, my lord, let us see page 22 of my IA, my lord. Page 22 is the resolution. Page 23 is the order. Well, at page 23, your lordship has got it.
Yes.
To Razakul Hussain, this is the petitioner. And these are not denied. Appointment letter. As per decision of the governing body, you have been temporarily appointed as an assistant librarian at Janapriya College so-and-so on consolidated pay as deemed fit by the governing body of the college with effect from GB resolution number 5, that is 28/3/2010. My lord has seen it. Now, my lord, next, I'll bring it to the next page, my lord. let us come to directly to the page daily attendance register, that page 28. That is, my lord, for the month of January 2011. My lord has seen it. Third line from top, daily attendance register for the month of January 2011. Page 28. My lord got it. My lord, the earlier page is this is the attendance register over here, typed copy. My lord, R. Hussain, fourth column. Assistant librarian. This assistant librarian in the month of. My lord, no, it is over here, assistant librarian. My lord, then August 12, assistant librarian. March 2013, assistant librarian. Then, my lord, for the January 2019 to December 2019, next page, page 29. My lord got it. Fifth column, Rajakul Hussain, assistant librarian. Then January 2020, first line, Rajakul Hussain, first column, assistant librarian. Then 2021 January, assistant librarian, last column. How can my friend say before this honorable court, he was a library assistant, and this document which I have shown, page 68, it is the mandatory requirement of every employee to submit that pro forma asking for his provincialization. It has to be submitted, my lord. There is no other alternative. There he asked the post, he desired the post of assistant librarian, thinking at that time he realized that he has got these additional qualifications, he can become the assistant librarian, and he was given the assistant librarian post by the governing body. When this honorable court, no, it was actually the authorities, my lord, I think my friend will say, authorities, while considering his post for assistant librarian, they declined to give him the post. So nothing to do with the grade 3 posts, my lord. This is the junior assistant and the library assistant. Over there, I being the senior, I was considered for that, my lord.
Okay.
And I was not occupying his post.
Okay.
He was never in the post.
Okay. Yeah, Mr. Sir,
My lord.
Education are officers and the organization of education.
My lord, my friend is relying to the 18 rule. 18 rule also, same principle, madam.
No. You come to section 4.
My lord.
It relates to research and or tutors the government service. So you are neither teacher nor tutor.
No, that is absolutely for teaching. My lord. My lord, my friend is relying on 2018 rules. Seven. My lord, 18 rule, my lord, at this, it starts from page 87. The section 4 is at 93, my lord. 18 rule, my lord. 18 act. My lord. Page 93. Non-teaching staff, section 4, non-teaching staff to the government servant, subject to fulfillment all other provisions of this act. The services of the non-teaching staff of all Bensar educational institutions. Lordship got it. Then, my lord, subsection 2, 3. Same condition is also here. If it is, my lord, 18 is applicable, then also one must have rendered 6-year service.
No, before submitting the other appointment, you have to show that you have the requisite qualification. You have been appointed as assistant librarian.
No, library assistant, I was appointed. My lord, he is showing some documents. I want to also show my attendance, my lord. And the so far the documents are shown at page 68 regarding the form fill up, my lord. That is, my lord, in the college, my lord, the college authority took signature, my lord. Then the here, my lord, it was fill up. There is no date of filling up, and it was attested on 6/3/2023 by the principal. It is long after the provincialization, my lord. The form is fill up, God knows, and there is no date of signing by Razzaqul Hussain.
There is similarity of your
My lord.
letter.
My lord, there is no signature. The petitioner's signature is not there, my lord. The date is not there, my lord. When he signed it, when it was prepared, nothing mentioned. But
Maybe,
there is
your signature.
the principal attested on 6/3/23. That means it is long after the provincialization. Principal has pursued him to come to that post. Perhaps in that line, he has these documents was prepared, and there is no signature. Whether it was prepared prior to the provincialization, can it be said, my lord, it is a document prior to the provincialization for the processing of the provincialization? Absolutely no, my lord. Because it was attested on 6/3/2023, long after the provincialization. Provincialization was on 2021. My lord, how the principal is misleaded, my lord? I will show, my lord. So there are so many documents showing that the governing body and the college authority has how he was misled, how the college is doing functioning, my lord. My lord, kindly, my friend has shown one documents regarding the resolution of my subsequent appointment, that I was appointed in the year 2010 in another post. Absolutely false, my lord. I have denied, and I have never resigned from my original post. That documents also I have annexed. Kindly have a look at the. It is also annexed in my writ petition also, the resolution. The resolution, my lord, in my writ petition, it is at page 100. Lordship will find the original photocopy at 103. It appears, my lord, that the resolution number 5 has been inserted later on, 103, my lord, and in my writ petition. 5 number prostav. Azir hobai Mozazzagul Hussainok library post assistant পদৰ পৰা পদোন্নতি দিয়া লাইব্রেরিয়ান হিসাবে নিযুক্তি দিবলৈ সম্পাদক দায়িত্ব দিয়া হল. Where is the appointment letter, my lord? And kindly see, there are some other documents. Annexer at page 104. 104, my lord. Here, these documents shows the staff whom was appointed when. Lordship will kindly see at 105, page 105. The serial number 9, close for the post of philosophy. One Shohid Yusuf Ahmed was appointed by resolution number. Lordship will find in the last but 2 column. He was appointed by resolution number 4 dated 28/3/2010. The same resolution. By the same resolution, this person, Shohid Yusuf Ahmed, was appointed. By resolution number 4 dated 20. The same resolution, my lord, does not contain that part.
That is 4. Yours is 5.
Yes, 4. Where is the 4? That person. The resolution, Lordship will find at page at 100, and the relevant part is
101. The resolution of 4 indicate that it is a matter of another person. Today's meeting has taken a resolution that let the secretary be given to the responsibility to appoint Shohar Ali Ahmed, Biniamin Narullah as mathematics teacher and Abul Kalam as the library assistant. This resolution number 4 does not tally with the resolution contained in 105, my lord. Same resolution dated 28/3, absolutely manufactured resolution, my lord. So far relates to me, my lord. The resolution number 5 was inserted subsequently. My lord, there are so many other matters I can show that the then principal has committed so many my lord manipulation of records. I never resigned from my post as a library assistant. Show me the resignation. Show me the joining letter in other. They cannot show my resignation from my original post. Me and making some register. They have made some in the Venture College. They made so many register, fake and correct. They also prepared some register and some other documents. I can show, my lord. They have manipulated so many records in the college. This resolution number 5 appointing me is a force, my lord. And my my lord, I have received as an my lord financial assistant, financial scheme, my lord, in the year 2011 as an library assistant. Then, my lord, my attendance, Lakshmi may kindly have a look at from page 55 onwards. Page 55 onwards, my lord, in my writ petition, answer 13 onwards. This was start from June 2021, page 55. And my friend is also showing some attendance register. Those are manipulated records.
Come on, these are your signatures. My lord, only just see page 35 once.
Yes,
My lord, if
yes,
he says
my signature is also
not
here.
under challenge.
My signature is also here, my lord.
My lord, this what my friend is saying, if I understand correctly, and if this before this honorable court, my lord, let us get to the one point. What my friend is saying that he was never even involved with the assistant librarian post. Is that what he is saying? If that is then it's very unfortunate because earlier round of litigation that was there. If your lordship looks at the page 80 is his earlier writ petition in my IM, my lord. My lord, is very unfortunate. My lord, page 80. My lord, this is his petition, Razakul Hussain. Now, would your lordship be pleased to come to page 82, my lord? My lord, see the third paragraph that is starting with during. My lord got it, during. During the deliberation of the matter, Mr. Sikdar, learned counsel for the petitioner on instruction, submitted that the petitioner does not have the requisite qualification to be appointed as an assistant librarian in the said college. And next paragraph, my lord. On instruction, Mr. Sikdar, learned counsel for the petitioner, further submitted that one Saleha Khatun, whose service was provincialized by the impugned order dated so-and-so as junior assistant of the said Janapriya College, expired after provincialization of a service. As such, the petitioner may be considered for provincialization of his service against the said vacant post, considering his service in the said college since 16/3/2003. And now, what he's saying, my lord, these are my lord, is the college will answer. That is the different thing. Now, only one glance, my lord, at the page. My lord, my lord, page 30.
Of your IA.
IA, my lord. This I say. Page 30, your lordship got it?
Yes.
What my friend is saying that it is manufactured that there are different register. See his name is the fourth column R Hussain, along with all the other stuff. His signatures are there. Assistant library. Next page, my lord, page 31. This is August 2012. My lord, see the fourth column. Razakul Hussain, assistant life. See the signatures along with all the staffs. My lord, NA, I can continue on the next page, my lord, page 32. March 2013, fourth column, Razakul Hussain, assistant life, assistant leave, his signatures. What he is saying that different register is maintained for him. All the non-teaching staffs are here.
My lord.
And from 2010, and I'll just show the judgment why it happened. It is only because of this honorable court passed this judgment, my lord, saying that these degrees will be not entertained by the state of Assam, these off-campus degrees. Then only he turned around and he wants to go back to his original post, which he has already given up. And he was, for long years, he was working as an assistant librarian. And it is almost, my lord, grade 2 post.
When he was appointed as assistant librarian.
My lord, this is the appointment order. This is page 23 I have given.
In your IA.
Yes. It is not under challenge. What my friend is saying now, denying nothing is under challenge. My lord, 23/5/2010, this appointment is given to him. And where is the concept of resignation and all this is a venture school? You have been from the library assistant to, because of huge degrees, master degree in library, you have now become an assistant librarian. Now you are saying I did not resign, but over here, as per decision of the governing body, you have been temporarily appointed as an assistant librarian at so-and-so college with effect from 28/3/2010.
My lord, this letter they have issued,
In
whether I
fact-
accepted,
in fact-
whether I resigned from my post,
No, no,
my lord.
in fact, what
And
happened?
my lord, above all, what is his Lucas, my lord, when he was not serving
No,
in the
I'm
post,
coming. I'm
not
coming.
serving in that post,
Only one.
and fulfilling total failure to
Okay.
fulfill the requirements
Sir, only one
of
minute.
that legal provision.
Okay, Mr. Sikra, please.
Page 24, my lord. Page 24. He is the person, otherwise can challenge my provincialization. See that appointment, my lord. When my friend was given the post of assistant librarian, there the post of library assistant fell vacant. See, as per decision of the governing body, you have been temporarily appointed as a library assistant. This Abul Kalam Azad, he is not before this honorable court. And my lord, what happened? When the provincialization took place, it has to go from the school to the district scrutiny committee, as your lordship is aware. From the district, it goes to the state. From the state, then the government approves and then the provincialization is given. Over there in the state level, they have considered the seniority among the grade 3 employees. This person was appointed only on 2010. That is the reason he was not considered, he was junior most. He was not considered for the post. And library, my lord, what junior assistant and library assistant is in the same cadre. That is, otherwise, what I'm saying, Rule 7 of the 1967 rules, that Assam Ministerial District Establishment Service rules govern their service. I being senior, in the same cadre, I was given the post. My friend is nowhere in the scene. It is this Abul Kalam Azad. At all, if he challenges that I am the post holder, why this Babul Hussain has been appointed? And I don't know why the provincialization was not given to my friend, that my the counterpart who is the representing this education department, they will say, my lord. My lord, totally unfortunate, totally misleading. He was there, it's true. But then because of the degrees he got off campus, while he was serving, he got the degrees from outside. When he realized that those degrees have been invalidated by this honorable court, suddenly he turned back. Now he wants that original post. But in the meantime, that original post has gone. Somebody else has come in.
One of the side, the content is governed by the Ministry of Road of 1967,
1964.
Matlab grade 3 and 4 matlab.
earlier governed.
Yes. Matlab in our stand is clear in page 99 of the writ petition. The speaking order itself. We also file affidavit, but the stand is very much clear in the speaking order itself, matlab. Page 99. I'll read from third para, matlab. Whereas it is found that Razakul Hussain, the petitioner, matlab, has joined as library assistant on so and so, and subsequently the Jonapriya College Authority appointed him as assistant librarian on 29/3/2010. As per records produced by ADC, Borpeta, the district level committee recommended the name of the petitioner for the post of assistant librarian. So when the college upgraded him to assistant librarian, and at the time when the process for provincialization of the non-teaching staff of the college was going on, his name was recommended for provincialization as assistant librarian. And why he was not given assistant librarian, Malad? But the service of the petitioner Razakul Hussain has not been provincialized as assistant librarian, as he obtained BLISC degree from Vinayak Mission University, Tamil Nadu, in off-campus mode through distance education mode 2013. And this off-campus mode is not recognized because, and pursuant to that, one judgment is there, Professor Yaspal, which says that off-campus mode, the universities, private universities offering off-campus mode PhD and MPhil degree, they are not recognized by UGC. That's why, the case of the petitioner was not provincialized as assistant librarian.
Okay.
Why was given it?
Page 99 is your stand.
Yes, my lord. And the reason for giving provincializing the service of the private respondent, my lord, the next para. Whereas, as per recommendation of the District Scrutiny Committee, Borpeta, and State Level Selection Committee of Higher Education, Assam, the service of Babul Hussain, the respondent was 7, my lord, who was originally appointed as junior assistant with effect from so and so, has been provincialized as library assistant, considering the seniority of date of joining and eligibility for the post in the college under the relevant act in force. As such, the Director of Higher Education above mentioned order pertaining to appointment of the incumbent is found in order, and so on. This is with respect to the appeal filed by the petitioner. This order. So this is the stand, of the state, because the name of the petitioner was never recommended for provincialization as library assistant. Yes, yes.
Victor,
My lord. My lord.
for the of the IA.
23.
24. Annexure 5.
Yes, this is another person, my lord. He was
After your promotion, not promotion, it is having been stated as assistant librarian. Another person was appointed as library assistant. Then where is your
my lord. My lord, the resolution itself is a manipulated documents, my lord. And my submission is that
manipulation?
the authority is to act on the law.
That's all right.
My lord, government has not responded to the direction of this Honorable Court dated 15 to 2024. There is an order to file an affidavit to justify this reason of this paragraph 3 and 4 of the impugned order. They have not filed any affidavit as on today justifying. My lord, the appointment to the private respondent has been made beyond law.
Where is that order?
My lord, at order dated 15 to 2024. They have to justify why a person has been appointed who never served in the particular post, my lord. My lord, they are saying that I am a library assistant, substitute promoter as an assistant librarian, whatever, maybe, but I was in the library department. But this man, the respondent number 7, when he has served in the department, library, my lord, he never served in the department. Therefore, this honorable court has earlier sought clarification.
Yes, sir. I have filed affidavit on 10/1/2025.
My lord, no whisper about this clarification, my lord.
The petitioner first have to prove his locus, challenging the the provincialization of the private respondent. Whether even if, for the sake of argument, if I say that if today the provincialization of the private respondent is cancelled, whether he will be eligible for provincialization for that post, library assistant man. No, because his name was not recommended for provincialization for the post of library assistant man.
My lord, whole thing is manipulation based on manipulation.
Regarding manipulation, my lord, there is nothing in the writ petition on that alleging malice on the part of the principal or the college authority, my lord.
My lord, I have so many allegations against the principal, my lord. Kindly have a look at, my lord, my affidavit.
He should have been made a party in person, my lord.
Yes, we have made party. Principal has been made party, but he has also appeared. I'll affidavit now. He is missing. What I can do? He has been made party, my lord.
No, not in person.
My lord,
not as the respondent lawyer.
Yes, respondent number 5.
As a court officer before this honorable court, to maintain the sanctity of the court, at least we officers should be clean in our mind to project our case so that honorable court can come to the right adjudication. What I'm saying, my lord, this annexure 10, it is mandatory for each and every individual to submit. It is his document where he is asking for the post of assistant librarian. My lord, suppose he did not ask, the district scrutiny committee ought not to have recommended him as an assistant librarian. My lord, matter ends there. It is the state level who found that he was not eligible as because of the degrees. Otherwise, the district has already recommended as an assistant librarian. If he would have been selected by the or allowed by the state, would have come before this honorable court saying, no, this was wrongly given. I should be given as a library assistant, not assistant librarian. Well, there should be a thin line of us as a court officer before saying something before this honorable court, man.
My lord,
Case can come, case
my
can
lord,
go.
I should make my submission first and maybe allowed to clear, my lord, make my submission incomplete. Then my friends may make submission. My lord, here in this case, that is a fact, my lord. I was, I am MA in philosophy and also some other degree. And the college has tried to fill up the post of library, assistant librarian. And they filled, but sometimes also I was also allowed to act as a lecturer in philosophy department because I'm having degree. But at the same time, I am also functioning. I continue to function as a library assistant. My lord, the college authority has this way, my lord, taken my service in.
Abul Kalam Azad.
My lord. No, my lord. I was functioning. I have the attendance register also. I have annexed in the writ petition. My lord, kindly have a look at my attendance register. And my lord, my friend has shown some documents. Kindly have a look at my documents also. The petitioner has also issued a certificate. Certificate, my lord, at page 42. Page 42. Kindly have a look at my lord. The principal, the then principal has issuing me certificate that I am rendering at that time as a library assistant. And the alleged appointment, my appointment upgradation is 2010. Why this principal has issued the certificate, my lord? Kindly have a look at my lord, page 42, the experience certificate. This is to certify that Razzaqul Hussain, son of Noyan Ali, inhabitant of village so-and-so, has been working as a library assistant at Jonopriya College, Baniarapara since 16/3/2006 till now. His character and conduct are found good. Then this is the certificate issued on 16/5/2011. They are saying that I was upgraded in 2010. Then, my lord, my attendance register I have also annexed in my writ petition. My lord, kindly have a look at my lord, page 55 onwards. Is June 2011, my lord. My signature is there as a library assistant at page 55A. At his name is also there, my lord. Babul Hussain in the last column. My column, my name is also there, my lord. 1, 2, 3. Fifth column. I am in fifth column. R. Hussain, library assistant. Then, my lord, there are so many attendance register. 2011. Then, my lord, 2012 also there onwards. 2012. The alleged appointment, had it been in 2010, I have accepted the appointment. Why I should sign here, my lord, as a library assistant? And my principal has issued certificate in favor of me. Then, my lord,
What is the pleasure you have submitted?
Me. Lord, it starts from page 30, my lord, in my
30.
yes, 30. My lord, I'm surprised with one thing. My lord, there is a huge difference of scale and everything between a library assistant and assistant librarian. Huge difference. As your lordship is aware, because of the qualification also. If he was a library assistant, why his name was sent for assistant librarian, and even the district scrutiny committee recommended him?
For provincialization.
Yes, it is the state who denied because of the qualification, because that qualification was not taken into consideration by the state of Assam. And my lord, only few days prior to that, there is a judgment of this honorable court by Honorable Justice S.K. Mehdi,
where clearly Vinayak and some other colleges, it was said that these off-campus degrees are not applicable. CMJ, even CMJ. Huh? Chandrakant, Jha University, Vinayak, CMJ, there are 4, 5.
My lord.
Otherwise,
I am not bothering about that degree.
No, no,
I am relying on that degree.
No, no, I am bothering because you have those degrees. Because of that only you got that assistant librarian.
No, my lord.
If he's not bothering now, he can't say, I am bothered because of those degree. He gave up that post.
Whether the resolution of the district level committee is part of the record.
No, I think my friend can bring it, Malo.
Does can you file it?
My lord, government should also reply on the order of 15/2/2024. My lord, there is a violation of law. They have not answered that point. My lord. They file affidavit, but this point has not been. Court was very strict on that. They have violated the law. They have person appointed who has never served in the post. So that is a violation of law, and that part has not been answered in their affidavit.
That can be answered easily, my lord. Grade 3 and 4, it is a known feature that is Assam Ministerial District Establishment Service rules cover that. Over there, considering that seniority was taken consideration. And second argument, my leg of argument will be, my friend, who is he to question my provincialization? As
Okay.
but
Let us see the district level
I think that will finish everything. If the recommendation is there as assistant librarian, what my lord is wanting to see, if the district has said that yes, assistant librarian, then everything goes. That can be done, my lord.
Well, that is not an alone will not serve the purpose. They are to fulfill the respondent authority is to comply the provision of law. My lord. They cannot pick up another person from the other post, never served in the department in the post, and has been provincialized.
It's
That
not a
law compliance of law is very.
No, it's not a PIL.
No, it's
My lord,
I have
simple
raised
language.
my legal point.
No, simple language. If there is no right, there is no writ. My friend,
I have right because I am
No, he
serving
doesn't have any
as
right.
the initial person who has been serving in the library.
Mr. Sikder, let us see the recommendation of the DL.
My lord,
yes.
recommendation will not be in my favor because
No,
the-
we'll say we'll.
I think government will be the best. District level scrutiny committee, my
Yes, the
friend is
you
okay.
the
They will be able to.
resolution. Heard the Sikder? Yes, the correspondent number.
Me for 7, my lord.
division method is available.
Private respondent.
Yes, my lord.
I'll be taking for 1 and 2.
Sir, does for respondent number 1 and open for respondent number PN4. Then available for respondent number 7.
7, my lord.
Number 7. After hearing learned advocates of both the parties, it is provided that with the learned counsel for the respondent number produce the recommendation of the district level committee dated whether the date is what is the date of that
That recommendation date to But I think only for assisting the court, my lord, I think it will be in the within the command of the director of secondary education, director of higher education, because from the district when everything comes before the director hire, then only it is placed before the SLC.
Let direction be given to both the government and the higher education department.
Can you say the date?
Date is not there.
Or it can be said as mentioned in the order dated so and so.
As mentioned in the order dated
28th August 2023.
28 August 2023.
Yes, sir.
Passed by
My lord, is Secretary to the Government of Assam Higher Education Department.
Secretary to the Government of Higher Education. The impugn order.
Yes, yes, yes.
No, my lord.
Speaking, yes, yes.
Speaking order.
Speaking order.
Is that page number, Mr. Secretary?
My lord, in my writ petition, my lord,
99.
it is
Page 99 and
page 90.
No, a repetition.
Yes, give the impugn order at page 99.
Okay. With the order dated 28 August 2023. Annexure 19 of the day. Place the matter of. Okay.
after 3 weeks, my lord. Recommendation after 3 weeks, my lord.
No, no. Wait.
The recommendation was in the year 2021 at the time of provincialization.
For 2 weeks.
My lord, it's
order.
My lord, it should not be in the first week of September, my lord. I will not be available.
After 2 weeks.
After 2 weeks, a date will be better, my lord. Because the part had. No, as the matter is.
Yes, it is. It will be listed as part heard.
At,
Take it that part.
May it please your lordship.
Yes.
Lordship, the petitioners here are an association of contractual teachers. And this matter was filed on 8/8/24, your lordship. And notice was issued on 12/8. However, lordship, affidavit has not yet been filed from the respondent.
Yeah, you have not filed your affidavit.
Yes, my lord. I am praying for some more time, my lord.
Lordship, it's been more than a year, lordship.
Earlier, it was heard by somebody else. So some decisions are also here.
Maybe in the motion stage, my lord. At motion stage, there are length hearing.
And Sharma, your lord.
Not heard it.
I am appearing, my lord, for responder 1, 2, 1 and 2, my lord.
1 and the Borwa.
3 and 4, my lord.
3 and 4.
My lord, we have received our instructions, my lord.
Okay. Mr. Khaton here. That time. And Mr. Borwa that he has received instruction. Then you file an affidavit.
My lord.
Depending on record the instruction. According to it provided the matter. After 2 weeks.
My lord, it can be 3 weeks, my lord.
After 3 weeks.
Lordship, in that case, can a date may be fixed?
In the meantime, the learned
Obliged.
Obliged.
Please, your lordship. My lord, would it, if your lordship is pleased to take the 29 first, my lord. That will be easier for me to show that it's a covered judgment, it's a covered matter.
Yes.
My lord, the matter relates to this. This school was ME school, my lord. It was amalgamated to the high school. Under the policy of the government, as your lordship is aware, the headmaster of the high school, the headmaster of the ME school becomes the assistant headmaster of the high school amalgamated. That is the scenario. Over here in Karbi Anglong, though our school was amalgamated to the high school, but we were not given the benefits of the assistant headmaster in that high school. So ultimately, my lord, there was a lots of deliberation, but then only thing, if your lordship directly comes to page 32,
My lord, corresponding, your lordship may only see that page 43 also, my lord. 32 and 43, my lord. I'll just show one thing, my lord, then your lordship will be.
Yeah.
Page 32, your lordship got it. Page 32. My lord, corresponding page 43. My lord, in 43, if your lordship looks at the name number 1, Chandrakanta Nath, petitioner number 1. His name appears in page 32, serial number 2. Then petitioner number 2 appears in page 32, serial number 1. Karuna Prasad Sharma. And petitioner number 3, Ibrahim Ali, appears in serial number 9, page 32.
Yeah.
And 4 is Gopal Chetri, that is serial number 10 in 32. Now, my lord, this page 32, page 33, my lord, I am 53 of the same list. This is the petitioner, Bimal Krishna Majumdar, before my lord.
Of the present petitioner.
Yes, my lord.
Yeah.
Now, my lord, without further, because in the judgment, in the order itself, the facts are also given, and what is the last order that I can, my lord, directly show my lord. My lord, page, paragraph.
So your pair is similar order to be passed
Yes,
here. Also.
yes, my lord. Similar order, it is exactly covered. I am on the same list. Yes, my lord. My lord, over here in paragraph 5, page 46. In view of above, this court is of the opinion that though creation of posts may be necessary for administrative purpose, it cannot be delayed any further. Accordingly, the present petition is disposed of, directing the respondent authorities to regularize the services of the petitioners as assistant headmasters in the upgraded amalgamated school, for which the authorities may take necessary steps, including creation of posts. Be that as it may, this court would hold that the petitioner shall be deemed to have been regularized to the post of assistant headmasters with effect from the date of amalgamation for all purposes. Accordingly, the respondent authorities shall release the necessary pay scale attached to the post of assistant headmaster of the high schools and grant the service benefits of the petitioners attached to the post of assistant headmasters from the date of amalgamation to the high schools within a period of 3 months. My lord, consequently, that benefit was given in page 47, annexure 15. My lord, 8/9/2020, under the authority conveyed by the Deputy Secretary, Department of Personnel, so and so, the services of the following assistant headmaster is hereby regularized as per Honorable High Court's order dated 16/9/2019 in WPC so and so, Chandrakanta Nath and others versus State of Assam and others with effect from the date of amalgamation of the school. Well, it is covered exactly.
Lordship, our affidavit is ready, but we are yet to file it. Your Lordship may kindly grant us 10 more
Their
days.
affidavit is required.
Yes, Lordship.
Why?
Lordship,
Because similar reliefs have already been granted to some other of the
Lordship, actually, according to our instructions, the post of the assistant headmaster has not been sanctioned yet, but we want to bring it in the format of an affidavit, Lordship. So
Pardon?
the post of the assistant headmaster has not been sanctioned yet, actually, Your Lordship, but we want to bring it in the form of an affidavit. So Lordship may kindly grant us 10 more days.
So that
It's
was
ready.
the plea. That was the plea in earlier in para 5. In view of the dispute of the opinion, though the creation of the post may be necessary for administrative purpose, it cannot be delayed any further. Accordingly, so and so. Be that as it may, this court holds that the petitioner shall be deemed to have been regularized to the post of assistant headmaster with effect from the date of amalgamation. And my lord, see the amalgamation order if your lordship looks at once. That is page 27. 26 and 27. 27 I'll come to my directly, my lord. My lord got it 27.
Mr. Katunia, you are appearing for,
Secondary education department.
is there any objection in passing the order?
No, one thing, the order impugned in the present restriction, it was passed in the year 2013. The earlier restriction was filed in the year 2015, which was disposal of 2019. But the present restriction, they have filed it in 2025. There's a delay of almost 8 years.
The cause of action arises every day.
That doesn't matter, they're sitting over the matter,
No, it's not sitting.
Once some of them have got the relief from this honorable court, now they are approaching this honorable court. There is a delay and laches on the part of the petition.
They are still saying post not created. The Karbi Anglong authority. Over there, the other side, another friend is saying delay and latches.
Yes, madam. It is apparent, my lord. 2013 order, and into 2025, they are challenging it.
But they are also similarly situated with those persons.
Yes, madam. They have approached in due course of time, madam. But the learned time, madam, petitioner, they are approaching in 2025, madam. So that has to be, as a report, my lord, and will obviously consider the delay and latches on the part of the petitioner.
Have you filed your affidavit?
Yes, sir.
You have filed?
Yes.
File or?
No, we'll file, madam.
Will file.
Yes.
Let them file. Or, your good name, please?
V. Shohei, Lordship.
V?
V. Shohei on behalf of Mr. J. Chutia.
Lord appearing on behalf of
Mr. J. Chutia, Lordship.
V.
J. Chutia.
J. Sotia.
Lordship.
J. Chutia.
J. Chutia, Lordship.
J.
Standing Counsel KA.
J. Sotia, Learned Standing Counsel for the
KAAC, Lordship.
That's number.
Okay. 427, Lordship.
No, Mr. Katunia,
I'm appearing for report number, my lord, 1 and 2, my lord.
1 and
1 and
Mr. Solia for 3.
Lord.
3. Sorry.
Lordship.
Yes, madam, same.
Lordship, in this matter, the university has filed an affidavit in opposition yesterday. We've received it yesterday. So we need to file a counter to that. Sometime maybe granted.
Whereas also I am repeating the university, Lordship. That particular affidavit we have, although we have filed yesterday, some objection is there also regarding typing of the pages, some pages. So it was not in that. We are not able to file that day, Lordship, because the registry has put some objection regarding typing part also. We'll clarify it and we'll file it, Lordship. Let Lordship may grant 2 weeks time, Lordship. In the meantime, we I am for Lordship. 328 Lordship. 328 Lordship as a senior standing counselor, Divoga University. 328 Lordship.
328.
328 Lordship.
That
For response number 9, private respondent. First time I am appearing today.
for respondent number 9.
9, my God.
For
আমি যদি objection আছে, context তো একই আছে।
না, content থেকে।
একটু difference নেই। আমি just
though he has filed the affidavit, yet objection has been raised by the and it permitted quick time by consent direct by the yet practically allow after 2 weeks.
Obliged.
May I please, your lordship? Lordship 31, 32, 33, and 44 similar cause of action, my lord. Here, my lord, 32, item number 32 become infractuous, my lord. He got the regular service, my lord, in another college, my lord. 32 is infractuous, my lord.
Let us dispose of one by one.
Yes.
First 32 then.
32, it is the infractuous.
Coordinator D. Borba, S. Das Borba, respondent.
32 হয় নাই?
Number.
All
respondent,
respondent, my lord.
So all the respondents. Sir, Borba, current object for the biggest that is statement the court that the has operative appointed in another establishment.
On the establishment,
And
regular
that's
service.
right. It's not within
Itu betul, no?
and
Itu betul. Itu betul.
close.
And two, 31, my lord.
30.
Yes, my lord, this case is covered by your lordship's order, my lord, where, my lord, that's petitioners, here, my lord, two petitioners, my lord, they were working as a lecturer in the polytechnic on contractual basis. And as per the cabinet decision, my lord, they have been terminated, and cabinet has taken the decision to appoint them the TA. Already, my lord, 100 demand post 100 posts has been filled up, but we have been denied. And I earlier occasion, my lord, in this similar situated another the contextual lecturer before your lordship, and lordship has passed an order. Lordship will find the order. First, come to the desk lordship's order at Annexer 18, page 75. my lord. And operating portion started from page 77. Lord. And turn to page 82, my lord. Paragraph 8, 10, 9, 10, 11, 12, 13, 14. This is the observation made by your lordship. This observation is totally covered by us. We were also working as a casual temporary part-time lecturer in the various polytechnics, my lord, in Silchar Polytechnic. And my lord, we were not considered as per the cabinet decision. Cabinet has taken the decision to the part-time lecturer will be converted to the TF appointee. And after the four months, my lord. And as per that cabinet decision, my lord, 100 candidate has been selected for TF. We have been denied, my lord. There were at the time of the taking decision, there were 264 lecturers were working as a part-time lecturer. Out of 264, my lord, only 100 were appointed. In this regard, my lord, earlier occasion, my lord, somewhere appeared, this is your lordship's order, and we were not denied. We are now coming before your lordship to pass similar relief as per this order, my lord. In the meantime, my lord, some changes has taken place, my lord. In this regard, as per lordship's order, earlier order 31/7/2025 order, or it passed in this case, my lord, we have filed an additional affidavit. In this additional affidavit, we were supposed to disclose these things that how many posts is still laying vacant. This laying vacant post is the occupied post by the lecturer temporary, part-time lecturer who were occupying the 265 posts. 265 posts, my lord. Kindly take my additional affidavit, my lord. We have filed on 4/8/2025, my lord.
Yeah.
My lord, there is a two advertisement at page 97. Page 97, Annexer 19. This is for the technical lecturer for technical, my lord. In the table, bottom in the table, my lord, total number of vacant posts 138. This is for technical. And down to next page, my lord. This is for the lecturer non-technical, my lord. 96 posts has been called for, my lord. Altogether, my lord. Altogether, my lord. 234 posts has been advertised. Technical and non-technical by two this Annexer 19 and Annexer 20. And my lord, accordingly, my lord, appointment has been made, my lord. And we were already been terminated. After that, my lord, 23 posts is still laying vacant. These 23 posts, which were already occupied by the casual part-time lecturer. There are, out of this, my lord, so many posts is still laying vacant. So many sanctioned posts is still laying vacant in every polytechnic, in every engineering college. My lord, my humble submission is that, my lord, since their post is still laying vacant after making the regular appointment, we are entitled to get the appointment under the TF. That 4 months may be extended to us on the light of this lordship's order. 1/5/2025 order. Similar, my lord. They were also working as the part-time lecturer in the polytechnic. We are also working as
Order dated 1/5/25.
25. And my lord, what happened, my lord? Prior to the cabinet decision, my lord, the director has submitted the data. Lordship will find at page 55, Annex 11. Page 55, Annex 11. This data has been submitted by the director before the secretary, my lord, and secretary placed it before the cabinet, my lord. In that data, my lord, annexed table 1, my lord. This is the total post occupied by the part-time lecturer in engineering college, and my lord, turn to 57, page 57, part-time faculty of polytechnic again engaged in the institution under DTE Assam. There are total 257, my lord. 257, my lord. And now, my lord, they were advertised the post for 234. They have made the appointment by regular employee. Still, my lord, 23 posts who were occupied by us, my lord. Out of that, my lord, there are so many posts are laying vacant, my lord. Sanctioned posts are laying vacant in every college, every polytechnics and every engineering colleges. My lord, this data is that for occupying the person who were working as the lecturer part-time, my lord. 257 out of 257, my lord. 230 by two advertised 234 posts has been advertised and accordingly filled up, my lord. And now at this time, my lord, 23 posts are laying still vacant, my lord. My humble submission is that, my lord, since that benefit has been extended by lordship order dated 1/5/2025, we are the similar to that persons who that petitioners, and therefore, my lord, my humble submission before your lordship that, my lord, we may be extended this benefit as extended by your lordship in the order dated 1/5/2025 in respect of the polytechnic. My lord. My lord, the order which my lord is showing, my lord, of writ petition 9/8 of 2025. This will not be applicable here because I will kindly have page 81 of the writ petition. There are 9 and 10. This order was passed on the basis of those submission that there is still posts are still lying vacant and advertisement. The result of the advertisement are yet not been declared at that point of relevant time. 9, para 9 and 10, my lord. Page 81. Para 10 is more specific. However, to a pointed query to so and so, submit that some posts are yet to be filled up, though advertisement for filling up the same by regular faculties had already been initiated and an interview was also held for the same. Whereas now, my lord, at this presently there is no vacant post, sanctioned post, my lord, as per my instruction. All the posts has been advertised, and my lord, while Anet Print is showing one data, my lord, 55, page 55, the data provided by the director to the secretary, my lord. So these are the posts occupying by, my lord, part-time lecturers, not necessarily all sanctioned posts. They are all working in part-time lecturers appointed by either the principal itself, principal of the institution, or the director, my lord. Now, regular appointment has been made for the sanctioned post, and as per my instruction, my lord, in fact, I have taken instruction on, today morning also. They are saying that no vacant post is there. All the posts has been filled up, especially the petitioner were holding.
Then I can affidavit order.
Clarifying the extent. Yes,
That
I
there
can,
is vacant.
that can be done.
By Monday, by
Tuesday. Tuesday. Well, kindly 1 week time may be given, my lord. Because I'll prepare then. I'll prepare then. I'll send it for vetting. And 1 week time, my lord. Nothing.
Thursday, my lord, today the matter was fixed for disposal, my lord. Lordship has been observed in the last order, 31 order.
both of it.
On-
And let's find that.
And then, my lord, 1 week time he is taking, my lord. On 14, my lord. 14. Just.
No, no.
বস্তুটো গলেই এতিয়া 19 too late, my lord. 11, my lord. 11 will be better. 11 September. 11 September.
Board alternate something that both are still like vacant in top of the public but it does something that's part that's like vacant that's present. By the file part of it record like that part of this is the matter of
11. 11. 11. 11. So 33 and 31 similar, same mileage, similar, right? 34 is a slight different mileage. This is for assistant professor engineering college. Here, my lord, I'm coming to the directly point. My lord, kindly take my additional affidavit, my lord. 34, high cost. Additional affidavit, my lord, 4/8/2025. There, my lord, at down to page 112, my lord, annexer 19.
Yeah.
Total number of vacant post 54. Advertisement number 2/2025 at page 112. 54 posts for technical, assistant professor technical law. And next turn to page 11, 115, annexer 20, my lord. This is also an advertisement. This is for non-technical, my lord. Only 6 posts were advertised. And my lord, in this regard, my lord, only 5 posts has been, 5 candidates has been appointed. Lordship turn to page 121, my lord. Assistant professor in mathematics. There is a 5. No candidate in ST Hills category could be recommended due to non-availability of the candidates. Altogether, my lord, 54 and 5, 59 posts has been filled up. And as per that data, my lord, what I have rely, my lord, at page, as annexer 10, page 47, my lord. Total post is 164, my lord. Page 48. Part-time faculty of engineering colleges engaged in the institution under DT Assam.
Yes.
That is occupied post, my lord, by the part-time assistant professor. Out of that, my lord, so many posts are laying vacant still. Sanction post, my lord. Only sanction post. We are all working in the sanction post against the sanction vacant post. And still, my lord, 106 posts is laying vacant. Oh no, one post vacant. 106 posts is laying vacant. 106 posts is laying vacant. As per the annex of 10. In respect of the assistant professor. 54 for technical and 6 for Non-technical, out of 6, my lord, only 5 has been appointed by the regular employee, regular recruitment. 1 cannot be filled up due to non-availability of ST Hills as per their result sheet. And my lord, now 106 posts is laying vacant as per the data page 848.
848
of my read petition.
Yeah.
There are the total assistant lecturer 165. Advertised only 59, both technical and non-technical.
No, how many?
For technical 54,
20?
for technical, assistant professor for technical 54, non-technical 6, only mathematics. Out of 6, my lord, 5 has been appointed by the regular recruitment. 1 cannot be done due to non-availability of ST Hills. And altogether, my lord, 59 posts has been filled up out of 165 in respect of the assistant professor. As per the cabinet decision, my lord, we are entitled to get the 3F benefit, my lord. That benefit has not been extended. Lordship has already been observed in Lordship's order, 1/5 order, Lordship.
But I'll take instruction, my lord, on regarding vacancy in this case.
This is clear, my lord. They are advertised. I have annexed in the additional affidavit. 106 posts is still laying vacant, my lord, in respect of the both in technical and non-technical, my lord. We may be allowed to continue as per Lordship's order dated
One petition.
Lordship.
Here only one petition.
One petition for assistant professor is 1 petition. 2 petitioners. 2 petitioners.
Sir, does it appear that some posts are lying vacant?
Look, I'll take instruction, my lord, because what instruction was given today, my lord, morning, there is no post vacant, and let me give. I'll my lord, in 1 week, my lord, along with the other matters, my lord, I'll take instruction.
It is neat and clear, crystal clear, my lord, from their advertisement in my affidavit. As per Lordship direction, I have annexed all documents. They have advertised only 54 posts for technical. At page 112, 54, and 6. Next is 6, my lord. At page 115.
Why you have not come prepared while there was a specific order that the endeavor will be made the matter?
Well, he is taken 2 times, twice he has extended the opportunity. He did not file any affidavit, my lord. Twice, my lord. Last order and prior to that order. He was extended to the opportunity.
My lord, that kindly give this fix along with the other matters, my lord. I'll get instruction.
In this matter, my lord, 106 posts is
because my lord, what was
For inspection incomplete from the data he has projected, it appears that some are
it is clear, my lord. 106 posts is still like that.
that you have not been granted opportunity file your affidavit for being inspected. Why the casual effort?
well, I'm sorry, my lord.
My fare is very much limited, my lord. I am paying as per Lordship's order. In the light of Lordship's order, my lord, I am making the submission, my lord. At this stage, my lord, my humble submission, my lord, similar relief may be extended in the light of this Lordship's order dated 1/5/2025.
Or then yes, not correct. For what? Record. That's it. Or buying pardon, polytechnic.
Different engineering college,
engineering.
common engineering college.
Engineering college is that is Give obtained written
Yes, yes, written instruction.
obtained regarding the vacancy post. Provided that like Monday.
Next month.
Return of the instruction at 2 p.m.
কবলাই জল কবলাই জল
The method. The method.
It is your lordship. The matter involves lordship prolonged suspension of the petitioner. The suspension order is page 33, lordship. He was suspended on 38/2024.
Yes.
Yes, Your Lordship, I've got my recent instruction, my lord, where we have on the last occasion, my lord, on 3rd of June, this thing has been extended. Your Lordship, please. The
So for last 1 year, lordship, no order was communicated to the petitioner. Review order was not communicated to the petitioner. And it was kept pending in the.
And moreover, my lord, he was arrested also. When he was arrested, my lord, whether he has informed when he has been out on bail, that also is not clear, my lord, in the petition, my lord. When he was arrested, my lord.
He was out on bail, lord.
He was out on bail, but did he inform the authorities that he was that he has been let out on bail? Because 90 days, my lord, that time it has to be counted from then, my lord, as per the judgment, my lord, the court bail.
First, I tell me when he was placed under suspension.
First, my lord, he was placed under suspension on Annexure 6, 38.
38.
38, 2024.
That suspension order.
Yes, lord.
Let's number
33, lord.
33.
Annexure 6.
And after this order, when his first suspension was reviewed,
I do not have the instruction, lordship. On the last occasion, lordship, they have filed an additional affidavit, lordship. Annexure page 43, lordship.
My lord, annexed all the three communications, my lord. There are three letters in that particular thing. The latest one being 3rd June, my lord. And the previous ones, my lord, 29 November, 24. Before, after that, my lord, 27 February, 25.
No. After 30th of August 2024, the first the suspension order was first reviewed on
29 November, lordship.
29 November.
As per the
Where is that order?
That I have given, my lord, I have given the copy of the thing, my lord. Three of the documents are there, my lord. First document is the latest one. Second document is the second, and the third first. One is dated 29 November 24, the first one. Second one is 27 February 25. Third one is 3rd of June 20. Latest one. And the reason has been assigned.
Lordship, as per although it judgment, it must be reviewed within 90 days, lordship.
It appears that after it was placed under suspension 8/24, they have conducted review and passed the order on 29th of November.
That is the 90th day,
It's 90 days.
90th day. 29/11.
दिल तो कितने पैसे
So for you do one thing.
Yes, sir.
You go through this order.
Yes.
Thereafter you come prepared. Will take the order.
Next week, okay.
Order. Order. That's if
Even.
sir, open the order.
what was
It
it
is part of five
नहीं नहीं
and by which the sub was extended for further order. Take copy of the order.
बिल खोलना बस
Order. So that we can obtain a correct and average it for on
Pledge.
orders for this.
Lordship, I will be allowed to have the copy of instruction.
I'll give him a soft copy mail of the order.
And the that's the part.
May, my lord, I request your lordship to look in, peruse the order dated 11/8/25. The direction was that, my lord, the
Okay,
private
thank you.
respondent's seniority list has to be produced. Then the department will produce the list and the interim order will be considered. My lord, if they have not produced, my lord, a short date may be given to them to produce the seniority list of the private respondent.
We have missed the item.
Part we can take that here.
My lord, I am for the private respondent, my lord.
Four.
Lord, a copy may kindly be furnished to me of the writ petition, my lord. That
This
I have.
copy immediate.
I am
Four.
for the respondent 4, my lord.
Four.
Number
My lord.
and
Please copy the
we
other.
have for
One and two.
1 and 2. The container subset if not obtain the then try to some more time get recording allowed with the method on content
My lord, little bit earlier, my lord, because my lord, only can I make a small prayer, my lord. Their last occasion, there was a direction. Interim prayer will be considered on the next day. That will be there.
care of the sometimes or totally internet for the furnish a copy of the yeah
My lord.
the proof of the thing.
My lord.
Fabulous.
My lord, only one small submission, my lord. What has happened already, court has not granted any interim relief, my lord. But my lord, the petitioner, my lord, who was earlier holding the charge, has retained certain documents of the school, my lord, along with him. He is not handing over to me, my lord, citing the present case, my lord, as the case is pending. So I will not hand it over. That is my instruction from the present respondent number 4, my lord. In the meantime, he can hand it over to
No,
me.
that should be through an application, not by a. That cannot,
No, no.
my lord, with that
It is
will be violation of a natural.
application is not.
If he has not, my lord, because our contention is that, my lord, he has refused to take over. That was recorded in the last order.
No, no.
He refused to take over, then he loses his seniority. So, my lord, in the whole list, he is the bottom of the
Then
list.
okay,
He
my lord,
cannot.
department is
Ad hoc.
already proceeding, my lord. He
Let the
perhaps-
department take the call. Let the department take the call.
My lord. Oblige, my lord.
On the last occasion, your lordship worried regarding this FRBM Act, one post, one candidate. This is the act, my lord. Section 7G.
Yes. Section?
Section 7G. Merit. 7(1)(z), with a view to ensuring timely discharge of current liabilities, especially payment of salaries to the employees, A, B, C, D, E, F, G, down below. Notwithstanding anything, notwithstanding any other provision contained in any act or rules, the select list prepared for the fresh appointments to vacant sanction posts shall contain names equal to the number of vacant posts notified at the time of calling for applications for filling up the post. Here, my lord, Guwahati University authorities have selected only one person, private respondent number 7, and the read petitioner name is nowhere there, my lord. So, my lord, the prayer, twofold prayers: one for cancelling the entire selection process, including the advertisement, and the second one, which would not be relevant, my lord, to appoint the read petitioner in that post. So, regarding first prayer, my lord, since the Guwahati University authorities have taken the decision in the executive council meeting, I have told the EC resolution on the last occasion. So, my lord, nothing remains. I mean, entire matter has become infructuous. For last more than 4 years, the students are suffering. So, they are going to, my lord, advertise the post afresh, my lord. So, my lord, since that status quo order is still continuing, we have taken the decision, but we could not execute in view of that status quo order as per this 5th March 2025 order. Otherwise, nothing remains. Matter has become infructuous, only academic interest, whether that biasness elements is there or not.
My lord, when I go through the provision of 7G, my lord, notwithstanding any other provision contained in any act or rules, the select list prepared for fresh appointment to vacant sanction posts shall contain names equal to the number of vacant posts notified at the time of calling for application for filling up the post. There is no dispute the fact, my lord, that there was one post which was advertised and there was one candidate whose name was recommended. But usually, my lord, which is the common parlance, that when a selection process culminates, there are a comparative statement which is prepared facing candidates in the terms of the ascension of their marks which they have obtained. My case, my lord, my case was very simple, my lord. My case was that I alleged bias in favor of respondent number 6. Respondent number 6 have not rebutted that. The private respondents have not rebutted my ascensions, including the subject matter act. The Guwahati University has not addressed on those claims. So those claims, my lord, they go unanswered as of now. Now I understand, my lord, that one post and one vacancy, that is what is the mandate of the act. For that, my lord, for that rule to now hold force, they have to cancel my appointment or they have to cancel the advertisement. That order of cancellation has not yet come, my lord. It is my humble submission because I preferred this repetition for my appointment. Your lordship would see the contents of paragraph page 13, my lord.
Sir,
Yes.
name is not selected.
Yes.
So then if we cancel the selection of the private respondent,
Yes, my lord.
then how can we directly appoint you? Because not there in the
Absolutely, my lord. In fact, what happens is when we prayed for setting aside the name of the private respondent, we only prayed for setting aside the culmination of the selection committee. The selection committee said it presided over a selection process where, in its wisdom, right or wrong, my lord, it decided that respondent number 6 should have held the post. Now, leave it to your lordship, my lord. My grounds are now limited. The fact is, the advertisement has not yet been cancelled. Now, if there is a definite direction, your lordship, that the advertisement has to be cancelled and the petitioner be also allowed to participate again. The petitioner, my lord, that I be given the liberty to participate in the advertisement, bearing aside the aspect of any deficiency in age. If that be allowed, because this petition has sat for 4 years, I had a claim at that point in time. I'm willing to come back to a lower post of associate professor. Now,
I'll be left remediless, man. Now, if your lordship directs that they reconvene the selection process and with the liberty that the petitioner be also allowed to participate, irrespective of whether there are any age deficiencies, then and the fact that the advertisement is cancelled specifically. Page 13, my lord, is the last prayer that may be relevant for your lord attention. Page 13, last prayer.
My lord, I think we are in the same page. My lord, the prayer regarding abandonment or cancellation of the selection process. My lord, we have taken the decision, but we could not execute. The second one, to give the liberty to take part in the selection process. I think that could be done.
That could be done. But the age factor is there.
48 now.
That has to be taken care of.
Yes, my lord. That could be,
Offline instruction that
my lord.
whether that can be done.
At the time of filing this,
43.
43.
Now I'll be 48.
So I'll receive instruction regarding that age aspect. My lord.
Let the matter be discussed.
Tomorrow, my lord.
That agreed by learned at the court. Was obtained by the on respect of age of the petitioner, the event of fresh selection, the event of initiation of the fresh selection. It's
Tomorrow. Most of the time.
Isn't contempt proceeding, my lord. 2018. The order has not yet been complied, my lord. Order has not yet been complied. Order is at page 12, my lord. The relevant portion is at page 16, my lord.
the Catalonia
Yes, my lord.
is of
Sorry, my lord.
2018 matter.
Yes, my lord. In fact, we have filed an affidavit, my lord.
55 now.
We have filed an affidavit, my lord, pursuant to the direction of this honorable court dated 29/4/2024. Respondent number 5 filed an affidavit, my lord.
Then why the matter is pending?
Thereafter, it has not been listed for quite some time, my lord.
No, on earlier two occasions, they have taken time for filing the affidavit, my lord.
We have filed, my lord, affidavit. That affidavit
When?
was filed on
the last occasion,
23rd September 2024, my lord.
that copy has not been served to me.
শুনি পোৱা নাই আপুনি নথি তেতিয়া বেলেগ হ'ব ন
No, no, মই
নাই এয়া এটা নামটো পাহৰিলো মই
24.
আমি 23rd September ফাইল কৰিছো
24. Yeah.
24
Oh, 24 matter is there. But it is a contempt
So
proceeding.
affidavit filed by respondent number 5.
Yes, my lord.
Yes.
It is of 27th of September 24.
Yes, my lord.
So you have
That-
not received the
Yes, my lord, that copy I have received. For 24 copy I have received.
why the order of the court could not be complied with?
I have given the explanation in that affidavit, my lord. These petitioners were terminated teacher of Hemaji district, Hemaji and Lakhimpur district, my lord. Subsequently, my lord is aware of the screening committee. There was a screening committee. They have participated in the screening committee, and accordingly, a decision was taken by cabinet to accommodate those teachers who were appointed illegally or irregularly, but they have been continuing their service, my lord. So accordingly, these prisoners were also accommodated. But my lord, they have already attained the age of superannuation. Therefore, they could not accept the accommodation order, my lord. So in view of that, my lord, since there was a subsequent development and they have subjected to a screening process directed by this honorable court, my lord, they have participated in the screening process. So it will be difficult on the part of the department to go beyond that the screening process, my lord. We have explained in that affidavit, my lord.
My lord, in fact, my lord, as my learned friend has said, these petitioners never terminated. That is reflected in the judgment of this honorable court. They
Yes,
are
my lord.
never terminated. And as such, the direction given by this honorable court, my lord,
Direction is that page number?
my lord, page 16, my lord. Page 16 is the relevant portion. My lord, kindly peruse page 15, paragraph 14. Director of Implementation, Assam, respondent number 3 in his affidavit has stated that proposed notice were issued to so and so assistant teachers of LP school in Dhamaji district on the ground that their appointments were illegal and against the non-sanctioned post. Reply submitted by those teachers, which included the petitioners, were found to be not satisfactory, and accordingly, Director of Implementation by his letter dated had directed the deputy inspector of schools to terminate the services of such teachers. However, it is stated that termination of the services of the petitioner was kept pending until further instruction. From the above, it is seen that though the termination notices were issued to the petitioners to which the petitioner had submitted their reply, which were found to be not satisfactory, consequently termination orders were not issued to the petitioner. As a result, the petitioner continued in service. Besides regularization of the service of the petitioner by Deputy Inspector of Schools, and their subsequent continuation in service has not been denied by the Director in his affidavit. In fact, Director in his affidavit has stated that decision to terminate the service of the petitioners was kept pending, which would mean that no termination order was issued to the petitioner. Be it stated that in the case of Dulu Devi versus so and so, which also related to service in LP school in Dhamaji district, Supreme Court referring to the earlier Constitution bench judgment in the state of Punjab versus Amar Singh of Harika, AR so and so held that mere passing of an order of dismissal or termination would not be effective unless it is published and communicated to the officer concerned. If the appointing authority passes an order of dismissal but does not communicate it to the officer concerned, termination would not be effective. In the instant case, the petitioners were appointed in the year 1989. They have rendered services for more than 28 years now. As a matter of fact, they were paid salary up to July 2007, that is for a period of 18 years. Continuous in service by the petitioner is not disputed, and as per the admitted stand of the respondents, no termination order has been issued to the petitioner. In such circumstances, withholding of salary of the petitioner would not be justified. Consequently, impugn order dated so and so is set aside and quashed. Respondents are directed to release the arrear salary of the petitioner from August 2007 within a period of 4 months from the date of receipt of the certified copy of this order. Current salary for the month of February 2017 shall be released within a period of 3 months from the date of receipt of the certified copy of this order. Requisition is allowed but without any order as to cost. And my lord, after this order, they have referring the other teachers' cases, my lord. But in fact, these judgment they have not challenged before the division bench of this honorable court, not filing any review application. So as per the FS court judgment, my lord, they bound by to comply the order. In the contempt proceeding, there is no scope for re-examination of the judgment and order of this honorable court, my lord, except to comply. So in case of the other cases, my lord, their case is unique, my lord. They did not have terminated, never terminated. And others, the 752, out of the 752, others are terminated. And that's why this judgment has been passed and is very clear. So respondents are having no other option except to comply with this order, man. And I have some effect for judgment is also there, which clearly stated. I have to Please, your lordship. First one is 2008 5 SCC 339 Mellon. Paragraph 32. While dealing, para 31 started, got it, Mellon. While dealing with such an application, the court is concerned a primary with whether the order passed by it has attained finality or not, whether the same is complied with or not. While exercising the said jurisdiction, this court does not intend to reopen the issues which could have been raised in the original proceeding, nor shall it embark upon other questions, including the plea of equities, which could fall for consideration only in the original proceeding. The court is not concerned with as to whether the original order was right or wrong. The court must not take a different view or traverse beyond the same. It cannot ordinarily give an additional direction or delete a direction issued. In short, it will not do anything which would amount to exercise of its review jurisdiction.
Okay.
And
Sir, here,
yes, ma'am.
this order was passed in the year of 17.
Yes, yes.
Okay.
In 2020, madam. 2020.
In
Screening process
view of
was
order, can you subject them to that cabinet?
Malat, the cabinet took a decision to undergo a screening committee in the year 2011, Malat. Thereafter, in the 2012, the screening committee was constituted and advertisement was issued from the persons who did not receive their salary, Malat. So those petitioners, they have participated in the screening process. And ultimately, the process was completed.
No. When the screening was held,
It, screening process started from the year 2015-16, my lord, and it was completed in the year 2018. 18. And the decision was taken in
completion of the screening process.
Yes, my lord.
This order came to be passed.
Yes, that is true, my lord.
Then how can you subject them to that cabinet decision?
They themselves participate in the screening process, my lord.
That's a different matter.
So subsequently, my lord,
In view of the order being passed in this petition, if were to comply with the order, you cannot compel them to participate in the screening process.
in fact, we have not compelled them to participate, but they have themselves participated. And result of the screening committee that we have found that they were appointed illegally or irregularly. So, my lord, a decision was taken. Those illegal appointees were continuing their services, my lord. A decision was taken to accommodate them as.
Yeah, I don't think that the affidavit filed by court help.
As per the direction of the Honorable Court, I have I bring it on record the stand of the department, my lord. So,
Right, but if that is the stand taken by the contempt, then we have no sort of
in that case, my lord, I pray for some.
you take instruction, otherwise we'll go ahead with it.
I'll obtain instruction, my lord.
Or, sir?
Yes, sir.
Or Islam, or and also hard, attorney or learned.
I am appearing for my lord. Response number 5, my lord.
Or 5.
5, my lord.
Or 5. After hearing the subject of the party, it is provided that obtain action in respect of complying with the order of court dated 7. This is the matter nothing.
Much up.
As partner.
Much up.
Obliged, Lordship.
My lord, this contempt was filed against an interim order, and subsequently the requisition has been finally disposed of by this honorable court lordship on 16/7/25. So they said they can already become infractors lordship. That interim order has been merged with the when it was fast, it was automatically merged with the final order. So it may be closed. They will have to come against the final order if it is not complied by this time. Only on this July 16, it was finally disposed of by this honorable court.
The interim order was passed in the year 2017.
17.
And contempt petition has been filed in the year 2018. And 7 to 8 years has gone by a lot. That order has not complied.
Ultimately, when the case was finally decided by this honorable court, that everything has been merged with the final order.
Page 15, Lord. 11, 15. 11 portion, Lord. Direction was issued to give current salary and other allowance.
And when the final order came to be
16/7/2025.
page number?
No, it is not annexed. I have found. It was contempt was against the interim order only.
Contempt was filed in the year 2018, Lord. This contempt petition was filed in the year 2018. And is the already main writ petition was disposed of.
A very detailed order has been issued by your lordship on 16/7/25. On 16/7/2025. On last month, lordship.
July 2020.
The specific direction was given by this honorable court.
You bring on record that
I think it is the duty of the petitioner also. It is their petition has been disposed of. Anyway, I'll
order.
Sure.
respond. To 1 and 2 load, both lordship.
What? And interim order.
It is 18/12/2017.
Passed by the court in WPC number 1/2018. Dated 18/12/2017. And that dating the penalty of the petition, the petition number 6435 of 2017 has finally disposed of by this court. By order dated
16/7/2025.
2025. And in the matter being finally disposed of, the interim order dated
18/12/2007
then merged with the final order dated
16/7/2025.
16/7/2025. And on the count this contempt petition become infractor and accordingly is subjected to close the same. But the order dated so passed by the court not by some record and record by the judge. The order counted for the responsible number according to the order of the court on
Next week, any date next week.
Tuesday.
I can bring it to an affidavit or by hand. I'll by hand. Yes, oblige your lordship.
What order was passed?
It's a very detailed and mandamus was issued lordship directing the authority to pay them salary and
Arrears salary,
everything.
current salary with interest.
Yes, it's a very detailed order. Yes. 41 lawsuits, all the respondents were already, respondent number 1 retired long back, 2 had already been expired lordship, and 3 also no longer is there lordship. One more will.
Lordship, petitioner will file, contemptor will file a IA
For
for impleting lord.
Third page.
A does.
It does learn it.
One lordship. I'll get one.
For one. They contact for one. That. Who died, sir?
Estimate 2, the director, earlier director has already been expired.
Number
2, SK Bhuyan.
SK Puya or Sandeep Puya?
Sandeep, SK, no,
Sandeep
Sandeep.
Puya, the erstwhile director, elementary education, some kind for suffered demise.
And 1 has been retired after long back lordship.
And the number 1.
Also retired.
Yeah, also
Retired long back.
also retired on super.
Yes.
He is there.
He is also no longer holding the post lordship.
And that the number 3 is Quota also no longer holding the post. It does turn it on the product. The customer will file an introductory application for implementing the present complaint. Present and price traffic. How many?
2 weeks, Lord.
Here.
Oblige.
And 43 will 42. Here, the both the respondents are no more there. The respond number 1 has retired. Respond number 2 is expired. So
yes,
I am calculable for implement.
May I please your lordship, 1 week time to file implementing for the
number 1 expired.
1 expired.
2.
2 is retirement.
After 1 night?
Sorry, 1 retired, 2 expired.
1 retired.
May I please your lordship, item number 43 is like
Same mill.
Same.
Order has complete my lord. I'm not received any amount, my lord. My lord, Mr. B. Deary was appeared here in this case for action number 3 and 4 for pension department. So he has some difficulty. He left the court, but he has given me the instruction that already the director pension has sent the PPO to the treasury officer losses on 21/7/2025. These 2 losses may kindly pay. It is already before that. Yes, the treasury officer. It is already sent to the treasury officer. My lord. I'm not receiving, my lord. Any amount, my lord.
So if you can 21/7, it will take 10-15 days at least, maybe.
Lordship, if I may, Lordship, I'm appearing for the Treasury Officer. I've taken telephonic instructions, Lordship. The petitioner has already visited the Treasury Officer. They're preparing the bill within a
They will
week.
get it. Definitely, they will
The
get it.
petitioner was present, Lordship. That is the instruction that I have received from the Treasury Officer. My learned friend, if It might not be.
So how much time?
Lordship, next week, Lordship may fix it next week, Lordship, by then,
Yes.
bills are being prepared right now. That is what my,
Third,
Hussain.
third. Yeah, for
two Lordship.
So I am for 1479
1479.
and Mr.
Five, my lord. Five.
And B Dewey for Lordship, he's for 3 and 10, Lordship.
And
For 3 and 10.
Huh? 40 days later. Dated
Eh,
7/20/25.
लिख लेना ये. ये date
By
लिख
the
लेना.
director of the Secretary of forwarding the PPO number
Yes.
in favor of the Malo.
Vimala Malao.
While of the for completion and termination and the method process is one week
Lordship,
according to the provided that the basis of this one week
Document of the
method process B and part
That's good. Date may be fixed. Date may be fixed.
okay. So that is
by the
Okay,
next
thank
date, the order will be complied
So
with.
10 days detail. 10 days.
Mallet, you also kindly see the last two orders, 18/6/2025 and 6/8/2020. And several occasions they have taken time, but last two orders are specific, Mallet. They have said that
Here,
my case,
I pray for 1 week time, my lord, for updated instruction. Well, telephonically, I have been informed, my lord, the joint committee's minutes has not been prepared, my lord, it has not been sent to the director office yet.
Mallet, earlier two occasions their statement was separate. Mallet. Kindly see the order 18/6, Mallet. They have said that my case was,
joint committee is still there.
there is no provision, Mallet. Joint committee provision is not there.
Joint committees, well, joint committee only has been delegated to verify, well, the dice data and all. They will not have their recommendation will not have a bearing.
That submission was made.
Third, sir?
Islam. Islam.
Third, already taken and the minutes are that after
Okay.
their
Grateful, man.
Obliged.
May please. This is a contempt petition, Lordship. The order was passed in 2022, Lord. Thereafter, Lordship, after 1 year, they have prepared an appeal, Lordship. That appeal was dismissed. The appeal dismissed almost 4 months, 5 months, Lordship.
Right.
Yes, 5 months back. What happened, Lordship, is a grade 4 employee, only he is a Chokidar, Lordship. He appointed in 2013. From 2013 till date, no single salary he has been received because of the compassionate appointment, because some procedural lapse, Lordship. Would direct it, complete the process within a 60 days, Lord. Now, till date, no compliance, no update, Lord.
Well, the matter was referred to the personal department, madam, because for compassionate appointment, the state level committee is headed by the chief secretary, madam. So, from our department, madam, we have already sent to the personal department. File is still lying with the personal department, madam. Today morning, I have received the instruction, madam.
it's when it is like
Last instruction, my lord, I have received on 1st of May, my lord. On that day, my lord, on 30th of April, the file was sent to the personal department, my lord. I have given the instruction.
After dismissal, same submission, Lordship, from last four months.
Yes, exactly, my lord.
Once the appeal is dismissed, Lordship, this is the duty bound, they have to comply within specific date, Lord. They prepare appeal after 1 year, Lordship. That 1 year already gone, Lord.
Just I am a grade 4 employee, Lordship, one Chokidar, Lordship. Simple decision, Lordship, they have not taken. No any decision. Because of this, Lordship, I am not getting the regular salary, anything, Lordship. Serving from 2013, Lordship.
This is instruction of 1st of May, my lord.
And appeal came to be
Lordship is, order is already on record, Lordship is 9/4/25. Appeal order is already there. In the appeal, it is also clearly mentioned that is the peculiar situation they have to comply.
order dated
9/4/25.
page number.
No, Lordship is the part of record in contempt. I have a copy, Lordship, kindly.
No, no, in the order passed,
Sorry, my lord.
the order passed, is not part of.
It's not a part of the record, my lord, but
No, this is okay, my, I
a,
have
a copy has
given.
been. Because contempt was passed against the order of the Honorable Single General.
Appeal paper, but the government.
There any something of
Government advocate.
Oh.
Government advocate.
Government advocate.
what is present?
Nobody present.
Procedurally the method. But that
You Ahmed. Lordship, direction is only respondent number 1, Lordship. They have to taking care all. Lordship.
That is the difficulty, my lord, because
It's not a
SFC is
direction
headed
to
by
the
the Chief
government.
Secretary. my lord.
Government is not party here.
So let,
Yes, my lord.
salary
That is the difficulty, my lord.
Wait, please, Your Lordship. I kindly request this matter to be taken with contempt case number 44 of 2025.
Pardon?
I kindly request take this matter with contempt case number 44 of 2025.
2025. So this is what instruction you have here.
In those there series of cases are there. Some petitioners have received salary, some are not received. Those cases were listed before the court for 11 today, and those were fixed after 2 weeks lawsuit. Yes. All those cases were listed today lawsuit before Honorable Court for 11 lawsuit, and those were listed after week recent. This will also come along with that lawsuit. Some of them have already received, some of them yet to get. Okay.
Third name? Your name?
M. Borua.
M.
Borua.
Borua. Your name? learned court of matter take contempt case number
44 of 2020.
44 of accordingly provided that take this matter as contempt case matter after
Yeah, Bijol. There are two cases. There public में kindly on the page 12 of the IA that MSC appeal that and then another order was there that lottery has that has been modified on page 12 para number 6 para number 6 only the single word adjudication that the respondent number 1 is allowed to withdraw the amount on proper adjudication. The registry has some confusion
actually not adjudication. This word was actually after proper identification. But private secretary has transcribed it as adjudication.
Yes, ma'am.
Creating confusion.
Yes, ma'am.
Sir?
BK Das, ma'am.
Learned court of by applicant and also hard normal to the respondent.
Insurance company.
Introductory application is hard by the applicant. So, making necessary correction paragraph number 6 of the order dated 10/1/2025. Sir does that while disposing of the interlocutor application being IA number IA civil number 407 of 2024. This court has observed in the paragraph number 6 that the respondent number 1 is allowed to withdraw the amount on proper adjudication. And because of the word adjudication, the registry has not been releasing the amount. And also from there is necessary. There is a requirement for modification of the state direction, paragraph number. Accordingly, taking note of the submission of learned counsel for both the parties, it provided that the word adjudication appearing after the word proper in paragraph number 6 of the order dated 10/5 in IS civil number 47. Henceforth, we read as identification. State of adjudication. In terms of this IS.
May I please the Lordship? Lordship, kindly 52 number item may be taken first, Lordship. Then it is a fresh repetition, Lordship. During the pendency of the contempt matters, that is 51 number item, they rejected the claim of the petitioner was rejected. That's why I have filed this present repetitions. That is item number 52, Lordship. Lordship, here, what happened, Lordship? In the year 1980, the school was provincialized, Lordship. And just 2 months back, later, that provincialization order has been kept in abeyance, Lordship, due to some dispute arose, Lordship. So ultimately, in the year 2008, Lordship, that order has been kept in abeyance, order has been vacated. And during this period, Lordship, during that kept in abeyance period, Lordship, that is 28 years. All the original petition, original teachers was retired, Lordship, and new set of teachers was appointed, including the present petitioners, Lordship. Lordship, when and Lordship, this kept in abeyance order was withdrawn or vacated, that all the petitioners, all the teachers, teaching, non-teaching staffs, service has been provincialized except present. So that's why initially, in the year 2010, the present petitioner approached before this honorable court. The honorable court has directed to place this matter before the high power committee. Lordship, in the year 2015, this high power committee has been rejected. The ground is showing that the petitioner was appointed in a provincialized school.
There is the ground law. So managing committee has no power. Thereafter, Lordship, in the year 2016, another order has been passed that the petitioner are, will be terminated. It is a direction has been given from commissioner to DO. So that order are already challenged, and ultimately both petition has been taken together in the year 2019. Lordship, this honorable court has been given that set aside that view, and this honorable court has said that when a provincialized school is kept in abeyance and it goes to its original status, that is Fansar school, and the Fansar school, the managing committee has all the power. He can appoint. Ultimately, Lordship, this honorable court has directed to file a detailed representation, and it also directed to the hyper committee to review and re-examine this their earlier decisions. Lordship. So ultimately, petitioner has been submitted their representation against Lordship. The hyper committee rejected this claim and taking a different view. This hyper committee taking a view that he was appointed as an additional teacher, and whatever this prior to 2016, whatever act, all the act has been struck down by this honorable court. So petitioner was not eligible to provincialize his service. So that order has been against challenge, Lordship. In the year 2024,
Let's not go at it.
Lordship, my submission is that why I am saying, Lordship, it's nothing to decidable, as because now whatever the reason has been taken, there's reasons already set aside by this High Court.
The council, see, we cannot dispose of this.
No, Lordship, my submission is limited. My submission is that, Lordship, let them call the personal appearance being given to this secretary. Why repeatedly they are violating this order, Lordship? This honorable court has this is 7 number petitions, Lordship. It is not a joke. Repeated High Court given direction, and whatever reason has been taken presently, their reasons already taken in the year 2015, and High Court already set aside. So, Lordship,
all the things.
Yes.
Okay, let them rest.
Lordship, that's why Lordship, my submission is, Lordship, that next month, Lordship, present petitioner is going to supernation. So that's why, Lordship, kindly 1 week may be given times, Lordship. In the meantime, Lordship, my submission is that a personal appearance may be called, as because, Lordship, it is a 50 number item, 51 is a yes. Yes, Lordship. Yes, why I'm saying, Lordship, their reasons, whatever reason have been taken.
Let them find their response.
Lordship, then, Lordship, why I'm saying that whatever court already taken decisions, that view has been set aside. Whether High Court committee taken the same view, that's why with due respect, Lordship, I am submitting that once High Court has been given a direction, settled, that view has been settled, issue has been settled.
So that is a one-sided story.
No, Lordship, it is record.
We have to hear them.
No, Lordship. Lordship, I am saying in contempt matters, Lordship, they have.
If you are insisting on their personal evidence, I will release this matter. I will not take up without hearing the other side. What to do?
Lordship, a short date may be given, Lordship. In the next date, positively they respond, Lordship.
You see, they have to obtain their instruction.
Yes.
They will bring on record by 5.
Lordship, that's why I'm saying, Lordship, positively in the next date, within short date.
I have no problem in fixing the matter in next week, but the problem is there. Problem is with them.
Lordship, I am saying another point, Lordship. In contempt matter, Lordship, kindly consider that part also. This matter may be a instruction will be sought, Lordship, may be seeking. Lordship, in contempt matter, Lordship, kindly peruse whether contempt is made out or not. I am saying, Lordship, and record is reveals is a completely violations. This High Court order, Lordship. Whether a government employee can do that thing.
No, can you pursue both the matters together?
Lordship,
contempt matter and this matter?
Lordship, that's
if
why
the order is complied with, whether this survive.
No, Lordship, I am saying, Lordship, that whether as per direction, whether they have complied or not, whether what order has been given and what they did done. Lordship, that's why, Lordship, I am saying, Lordship, that in contempt matter, Lordship, maybe Lordship.
I hope.
It didn't have to be-
It is 12, 5,
Okay.
also for direct. The response for the order dated by that all the response
Up to 6, my lord.
all the performance updated.
Lordship, in 7, Lordship, my submission is that maybe it's stuck down, Lordship. That's because
One, two, three. Since Mr. Carton here and third application of the learned that or that I according to taking some learned the name of the number then track of the both it's not matter
Well, better, let me give at least 3 weeks time so that I can file an affidavit.
Lordship, in the meantime, Lordship, my petition will be infructuous.
How can it be infructuous, my lord?
Lordship,
If he is entitled for provincialization, after his retirement also, she will get the benefit, my lord.
My government will be taken a stand that your first prayer is to provincialize my service. Now you are retired. So that's why, Lordship, I am saying, Lordship, a short date within 2 weeks, it is sufficient, Lordship.
Exactly. Right of provincialization is always there, my lord.
one
My lord.
concept further I with everything
I am for 1, he is for 2, my lord.
one is the matter along with the fight for further if on actor if demonstrated for the court that the direction by this court has not been complied by
Yes.
the
Lordship,
In fact, it is complied with. That is why he filed a present petition. Otherwise, he will not, my lord.
Lordship, one more question, Lordship. Lordship, one observation may be given, Lordship. In the next day, they positively file a response there. Lordship. Yeah, one observation, Lordship. Positively, otherwise, Lordship, it will be take.